My lord, I beg to mention for item 19. My lord, this matter relating to my lord, item number 19.
You want an adjournment?
My lord, it's matter in function because it relates to selection appointment of Kazi. Kazi, my lord, no more, my lord. Said maybe closes workshops.
It's the ARC Guard Limit Council appearing on behalf of the petitioner. Submits that in view of the. What is that act?
My lord, Marriage and Divorce, Muslim Marriage and Divorce Act 1935. Under that act, my lord, Kazi was.
The amendment made. In view of the repealing. Is it repealing?
Repealing, yes.
In view of the repealing of the Muslim Marriage and Divorce Act 1935. Nothing further remains in the instant petition. Accordingly, the instant petition therefore stands closed, as it had become infructuous in time order if any instant
Item 24, my lord, I pay for adjournment, my lord, may come up after vacation. Item 20.
Item 24 to be listed after vacation.
Leave your. May I please your lordship, my lord? What happened, my lord? Your lordship had disposed of a matter, my lord, on 26/9/2020, Arunachal, series of matter, my lord. Graphite case there. But my lord, in website, my lord, 5 matter, which has been old matter, my lord, where your lordship directed to my lord list the matter after J20, that has been uploaded. But the matter where your lordship has directed that within 15 days they shall submit all the.
It is being uploaded now. It is being uploaded now. That order is uploaded. You just find out.
That's all.
That will be uploaded. Because you see, there were certain corrections to be made.
Also,
And more particularly, what has happened, I have inserted section 27 of the General Clauses Act. Because unless it is a registered document, I can't be in service. So that aspect was brought in. And it happened only on that day and Friday. Yesterday it had been, I think you will get it by today.
with the instruction of the petitioner, I want to lordship item number 22.
The M. Khan, the Learned Counsel appearing on behalf of the petitioner submits that his instructions to withdraw the instant petition. Accordingly, the petition stands closed for withdrawal in time of his stands.
As regard item number 30. Respondent file.
Give your name, whoever is it.
As regard item number 36, your lord. Your
Yes.
lordship may not like 3 people.
36, there is no matter. I don't have a,
36.
I don't have 36 in my list.
Cautious official. Item number 30. Item number 30 to raise your lordships. This is a matter which was already pending in the court. There was an appeal which was filed with the DRT by the bank. When this matter was pending, there was an order passed by the recovery officer. Now the DRT has substantially heard the matter and passed an order in the favor of the bank. I have been handed over the order. I'm only seeking sometimes the lordships to file a writ because I have to challenge this because substantially the subject matter is pending before the lordships to be decided who's going to have a first charge on the right on the dues. But now the DRT has already decided this matter substantially. I'm only seeking a week's time if the lordships give me a file a writ petition tag it along with this writ to be heard together.
You want an adjournment?
Yes, I have to file a writ petition. So I'm praying for lifting of the motion letter on Thursday. Much. I can hear you. The which orders.
I take care of videos. Okay, fine. Yes.
Prayer for acquisition of one affidavit by Lord with regards to item 35. Highly open.
Yes, please, your lordship. My lord, I beg to mention for listing of a case lordship for motion lordship on first outline.
That lordship I beg to mention the matter for listing in the motion for a lordship on Thursday lordship. Lordship another clear in regard to item number 20 lordship.
as per the instructions from the petitioner lordship, the matter has become infractions lordship. So let the
Zero,
matter be
item
closed.
20. What is your name?
Chairman.
Hmm?
N.A. Majarpura. My name is not reflected in against that, I mean.
This is by
Petition.
Mr. A.R. Bhuyan
A.R.
and M.I. Hussain.
Yes,
None
I-
of them are there.
Yes, no one is there. I am seeking, I'm praying for on behalf of Mr. A.R. Bhuya lordship.
Where is he?
He is not available to the lordship due to his illness lordship.
Then mention the matter when the matter is taken up. Because otherwise it will be improper. Your name
Obliged.
is not there.
Obliged, lordship.
Lordship, with regard to item 31, is fixed at two lordship. We have filed one additional affidavit that may be called for.
May I please, your lordship? Lordship, I beg to mention for listing motion matter, lordship.
Yes, Mr. Mazumdar.
Item number 32. I need to find a reply also.
Huh?
Item number 32, I received an affidavit in opposition. I need to find a reply. It may come up after vacation. in the meantime.
The request of the learned counsel for the petitioner matter to come up after vacation.
Have read about back to me for item number 17, your lordship. For instruction received, I may be allowed to withdraw your lordship. Withdraw your lordship.
Withdraw. 17.
17.
Who are you? What's your name?
I am Arpon on behalf of M. Malakar. Your lordship.
No. Anybody has to come. Otherwise you be there when the matter is there.
So Lordship, I beg to mention a motion matter for listing on Thursday.
May I please, sir? I beg to mention item number 21, madam. In item number 21, we are going to file affidavit today, madam. The matter may kindly be part of and listed after vacation, madam, with the affidavit.
You are for?
A petitioner, madam. Kamesh Talukar.
The request of the learned counsel. You have informed the other side?
Yes, melody, a special.
The request of the counsel for the petitioner matters can return to the list of activities.
Item number 7 and 8 has become a little infructuous. Because the matter is related to the no confidence motion against the president of the Gaon Panchayat. Now, term of the Gaon Panchayat has been expired.
Mr. M. E. Mandal, the learned counsel appearing on behalf of the petitioner submits. Petitioners in both the writ petition submits that the writ petitions were filed against the no confidence motion of a no confidence motion
Against the Gaon Panchayat president.
against the president,
President of the Gaon Panchayat.
the president of the Gaon Panchayat, who's taking into account that the period of the Gaon Panchayat is already over, nothing further remains in the instant petition. Taking in that view of the matter, the instant petition stands closed as it had become infructuous. In time or this, if any, stands vacant.
One for withdrawal.
Yes,
Your lordship.
Withdraw?
Yes, already departmental approval granted your lordship.
the learned counsel appearing, Mr.
Armudin.
Armugundar, the learned counsel appearing on behalf of the petitioner submits as the departmental approval has been granted. Departmental approval have been granted. Got it?
Ah.
Have been granted. The instant with petition has become infructuous, and as such, the petitioner would not like to press the instant. Accordingly, the petition stands closed on withdrawal. In case or the pending stands completed.
Supplementary item 42 and 43 for withdrawal. May I please?
You got the money?
Yes.
The SI Kandal and council appeared, both are similar.
Similar matter, but our council is different.
It's okay.
My case lot is second item lordship. Delete has not fought lordship.
Wait. 3074, huh? Mr. SI Kandal and council appearing on behalf of the petitioner submits that as the petitioner have already received the ex gratia amount, petitioner is not petitioner does not want to proceed with the instant petition, taking into account the above, the instant petition stands closed on withdrawal. Yes,
Lordship, in the next item, Lord 43, Lordship, the petitioner has not got his relief, Lordship. The amount has not been received, Lordship.
then why do you want to withdraw?
No, Lordship, wrongly.
Okay. Item number 53. What are you asking for?
Lordship, I'm seeking for compensations, Lordship.
For why?
Lordship is, for a petitioner's husband died,
Mr.
Lordship.
Counsel, how do I help you? Tell me. Have you seen the petition? Somebody has issued notice, but tell me you don't have a prayer. Huh? No. What to do? Mr. Counsel. File a fresh one.
Lordship,
Mr. So the learned counsel appearing on behalf of the petitioner submits that in a there are certain formal defects in the instant petition, taking into account that the petition does not have a prayer. Pusto. Accordingly, he submits that he may be permitted to withdraw the instant petition with the liberty to refile by making the appropriate corrections, by incorporating the relief. Pusto, taking into account the above, the instant petition stands closed on withdrawal. However, the petitioner would be at liberty to refile by removing the formal effect.
I leave this.
How did you file this petition in this manner?
No, there is, there, Lordship, but half,
What half?
half portion.
You read that. Read that. What half is that?
Lordship,
Read it. Read it. Let everybody.
Lordship, under the aforesaid fact and circumstance, it is humbly placed that your Lordship would be pleased to admit this petition and call for record so and so. And first, a read of mandamus should be issued, directing the respondent authority to pay rupees 8 lakhs to the petitioner's lord.
Nothing more.
Yes.
We lost out some page.
It's lost, if one page is lost.
For motion item number 2.
Lordship may not like to take up this matter, Lordship.
What?
May not like to take up this matter, Lordship, because senior counsel Dr. Saraf will appear in this matter, Lordship.
In a contempt matter.
Because the correcting read petition was read by the Dr. Saraf.
So what?
In this matter, he will not. He will appear, Lordship.
Why?
Lordship,
Are you referring to contempt case?
Lordship.
Here you are having M. Dotto, S.R. Gogoi, N.C. Das,
Name
A.
is not shown
Goel,
in the first
A.
list, Lordship.
Chaudhary, J.P. Moore.
Lordship, I am JP Moore, Lordship. Lordship, senior counsel name is not shown in the first list.
What is the matter about? Why you are asking for filing this contempt?
Lordship, otherwise, after some time then, Lordship.
Huh?
After some time, Lordship.
Why is this contempt?
Continue that Lordship, the order dated Lordship 3/9/2024. Order is not complied by the police authority.
Where is that order?
Order page 29, Lordship. Operative part is page 23, Lordship.
Which order?
It's starting from the page 21, Lordship. Annexure 3, page 21, Lordship.
This is the direction.
That page 23, Lordship. It's starting from page 23.
2024. All the demand for enforcement. Now what happened? What happened now?
Police not complying with this order also.
Huh?
We-
Has your possession been disturbed?
Yes, Lordship.
But after the order passed by this honorable court, my lord, prisoner personally approached the officer in charge, against order of superintendent of police. But my lord, they have done nothing despite the order passed by this honorable court. And my lord, we have given later page 31, your lordship may kindly see. In fact, they denied to obey the order passed by this honorable court. Page 31, your lordship may kindly see.
Here there is a direction only upon the respond number
True,
6.
your lord, since respondent number
The
6,
possession here.
officer in charge,
Nature and allegations, more particularly the allegation of collusion between the police and the respondent, where it is provided the possession of VR shall be protected till the returnable date, and more particularly the OC shall ensure
Fine.
that the possession of
Page-
VR are not
page
disturbed.
32, my lord, we have
But
done
Mr. Counsel, you have already been dispossessed.
not disposed, my lord, after the order.
Already written out here.
My lord,
And as such, the order of possession in favor of the caretaker was to continue.
your lordship may kindly see the order passed by this honorable court. Page 20. And operative part is
Have forcefully entered into the house and stolen properties. So you have already been, they have already entered your house. Where is the question of your possession?
there is no house there. There one area.
Hmm.
Open area is there.
So here you mentioned the order says about house.
One house is connected with my house is connected with that. After that area, my lord, one house. This is in fact entrance of the house.
Huh?
Entrance of the house, and your lordship may kindly see the order passed by this honorable court, directing the officer in charge to ensure my possession, your para 11, page 24. My lord. And we have given letter to officer in charge. My lord requested him time and again. Then I approached my lord superintendent of police and met personally superintendent of police. But my lord, they refused to do anything, your lordship, despite the order passed by this honorable court. Para 11 is the clear-cut deliberate violation of the order passed by this honorable court. Page
You
24.
were lucky enough to get such orders going.
Because of the, my lord, kind lordships are sitting here.
Let it go before that judge will pass this. List this matter before taking into account.
On
that the
fourth matter is
incident
fixed, my lord. On fourth, writ petition is fixed.
List this matter on 4/10/2024. To the appropriate bench.
Along with my lord, 4477.
I don't need to say, it is already there, no? Will come before him, so this will go, when I say appropriate bench, means not before.
Deep loss.
Appropriate bench, not before.
That's right. That's right.
Yes, what is this?
My lord, here the petitioner, who is a senior citizen, is seeking to enforce his rights under the maintenance of the Senior Citizen Act. My lord, so far, I am a senior citizen, that is not in dispute. This is the second time we have come before this honorable court. On the first time when it came, the matter was remanded back to the tribunal under the act. And this was the first case which was heard by the tribunal in the district of Kamrup Metro and there was no machinery to deal with it. Now, so far the house of the petitioner is concerned, it is I have inherited from my father. I have constructed a house here by obtaining the loan. But my son and daughter has thrown me out of the house from September 2023. Either I'm living in hotel in Guwahati or in relatives' house. I have no place to stay in Guwahati. Now, so far the law in regard to eviction of the sons and daughters or the siblings or the sons and daughters, but it is no longer res integra or res nova, that under the maintenance of the Senior Citizen Act, the senior citizen has all the right to evict them from his house. So that's why we are before your lordship, because in the impugned order at page 70, the tribunal has struck off his hands by simply saying that it is a property dispute, whereas there is no property dispute. It is my house, and I don't want my sons and daughter who has ill-treated me and thrown me out of the house. And so what? The entire scheme of the act, Madam, your lordship will find, has been discussed in the judgment of 2021-15 SCC, page 73. That is as Vanita versus Deputy Commissioner, Bangalore. Your lordship will first look into the definition of maintenance and the overriding effect of the act. Maintenance has been defined under section 2B. Maintenance includes provision for food, clothing, residence, and medical attendance and treatment. Then your lordship will see senior citizen at 2H. Senior citizen means a person being a citizen of India who has attained the age of 60 years or above. Then your lordship will see 2K. Welfare means provision for food, health care, recreation centers, and other amenities necessary for the senior citizens. Then section 3, your lordship will see the overriding effect of the act, which is the non-obstante clause. This says that the provisions of this act shall have effect, notwithstanding, that's the overriding, my lord, anything inconsistent therewith contained in any enactment other than this act or any instrument having effect by virtue of any enactment under this act. Then your lordship will kindly see section 4(3). The obligation of the children to maintain his or her parents extend to the needs for such parents, either father or mother or both, as the case may be, so that such parent may lead a normal life. Then 5 talks about the application for maintenance. 6 talks about the jurisdiction and procedure. Then your lordship will see section 8. It is the summary procedure. Because a senior citizen cannot be sent to a civil court to execute his right to stay in his own house. Then there is a power of, my lord, in the civil court also, there is one. Jurisdiction of civil courts is barred under section 27. Then it also talks about properties which have been transferred to be void in circumstances that is mentioned in section 23. As one. This is the main judgment from where it flows. Subsequently, there are judgments of different high courts, including Punjab and Haryana, Delhi High Court, and Karnataka and all. Only so far Guwahati High Court is concerned, there is no judgment of this honorable court. So this is the first case, I think it's just come, and on the basis of it, the submission was made on the day one when it was there, moved that there are maintenance tribunals under the act. But when we approached the concerned officers, they were also surprised that there is such an act and maintenance tribunals are yet to constituted. My juniors have to go and explain to them how the tribunal function, what is the role and all. There also, this order was passed on 27/3/2024, and still we are running from door to door to get my sons and daughter-in-law evicted from the house.
See, the question of eviction does not exist.
Well, what eviction only has been used.
You cannot go for
I can take your lordship to all the provisions of the
eviction does not arise. You may ask for maintenance, you may do whatever may be,
Yes.
you may have a right of censure, everything is there. But the question of
But
asking
what-
for eviction is not there.
Well, this is the not.
Then all senior citizens can very well go ahead and file, instead of filing suits, go here.
That's what the act contemplates.
No,
With utmost
never.
respect. With utmost
That can't be
respect,
there. Then in all civil disputes, they're
No,
not necessary.
No, where the property and title is not disputed, there is no civil dispute. It's my
How
house.
are you, how am I going to see
No, no,
that
but
the
you're not
property
see-
is not in
No,
dispute?
that's why the tribunal has to see. Tribunal has shut off his responsibility by saying that it is a property dispute. Where is the dispute? This is my house. I'm not a tenant in my house that I have to go to that your lordship will see the judgment. Or I can give the entire list of judgment of the Punjab and Haryana High Court, Delhi High Court, including the Supreme Court. Your lordship can see the entire scheme of the act has been discussed in section in paragraph number 25 of the Supreme Court judgment.
Here we have to go that they are a senior citizen or here the parents will be entitled to maintenance. There is no quarrel with that. But the question of asking for eviction,
Yes.
not possible.
A Chief Justice of the Punjab and Haryana High Court had to file an application before the.
Fantastic. Chief Justice may file whoever it is. I'm not concerned. I'm concerned about here. Finally come to the point
Then
here.
your lordship look
Here,
at it.
in which case there is a suit being filed, any proceeding for eviction can be filed under this act. Show me.
Yes, your lordship will kindly see paragraph number 24 of the judgment.
We'll see. First show me from the act.
Yes, ma'am. Your
Where is it says that you can
Madam-
ask for eviction?
my lord, no, my
Show
your
me
lord- no, your
where you
lordship will-
can ask for eviction.
No, madam, your lordship will see the scheme
Mr.
of the
Mr.
act
Kumar,
first. madam.
Mr. Kumar, kindly come to the point.
Yes.
I'm asking you, where is the provision that you can ask for eviction?
Yes,
You
sir.
may very well ask for maintenance. You may very well ask for welfare. Everything you have a right to ask. But where is the ask that you can go for eviction of somebody? Show me that. Where is the power of the maintenance tribunal to do?
My lord, your lordship, the Supreme Court has explained in paragraph number 25, your lordship will kindly see paragraph number 25 of the judgment. It will clear the concept.
Yes.
The substance of subsection 2 of section 23 as submitted by the second and third respondent is that the tribunal had the jurisdiction to pass an order directing the eviction of the appellant, who is the daughter-in-law. Here, of course, there is a dispute between the provisions of the Domestic Violence Act vis-a-vis the Senior Citizen Act. But in this judgment also, the Act of 2007 have been, according to the submission, the power to order eviction is implicit in the provision guaranteeing a right to receive maintenance out of an estate and the enforcement of the right. In supporting the submission, they have referred to the view which has been taken by several high courts, indicating that the tribunal may order the eviction of a child or a relative from the property of a senior citizen, where there has been a breach of the obligation to maintain the senior citizen. The tribunal under the Senior Citizen Act 2007 may have the order to order an eviction if it is necessary and expedient to ensure the maintenance and protection of the senior citizen or parent. Eviction, in other words, would be an incident of the enforcement of the right to maintenance and protection. However, this remedy can be granted only after adverting to the competing claims in the dispute. It is necessary to recapitulate that the situation in the present case is that eviction was sought by of the daughter-in-law, the appellant. The land where the house has been constructed was originally purchased by the son of the applicants who are seeking eviction of the daughter-in-law. The son had purchased the property a few months before his marriage to the appellant. He had subsequently transferred the property by registered sale deed to his father, and the fact that it was the first consideration after lapse of several years is of significance. The father in turn executed a gift deed in favor of his spouse. The applicant has asserted that she had been living in the house as a matrimonial residence until the application was filed. Her spouse has, according to her, deserted her and the minor daughter had left them in the lurch. The electricity to the premises was disconnected for non-payment of dues. The daughter has sought admission to an engineering degree course. However, her father, respondent, has not provided any financial support. The transfer which took place cannot be viewed in isolation from the context to the ongoing matrimonial dispute which has taken place. The issue is whether the appellant as the daughter-in-law and the minor daughter could have been ousted in the above manner. Then this provisions of the protection of women from domestic violation has been discussed. And here also, your lordship will see paragraph number 28, because here maintenance means includes, it doesn't mean only means and includes. So 28 gives the distinction between means and includes. Then your lordship will go. Then your lordship will look at paragraph number 34. Your lordship look at paragraph number 34. Section 36 of the Protection of Women from Domestic Violence Act 2005 stipulates that the provisions of the Act shall be in addition to and not in derogation of the provisions of any other law for the time being in force. This is intended to ensure that the remedies provided under the enactment are in addition to other remedies and do not displace them. Now, your lordship will take note of this slide. The Maintenance and Welfare of Parents and Senior Citizen Act is undoubtedly a later act, and which you have noticed earlier. Section 3 stipulates that its provisions will have the effect notwithstanding anything inconsistent contained in any other enactment. However, the provisions of Section 3 of the Senior Citizen Act 2007 Viewed an overriding force and effect would not by themselves be conclusion of an intent to deprive a woman who claims a right in a shared whole as under the PWDV Act 2005. Then it says that out of these two acts, since the first act is in beneficial legislation, both are salutary legislation, but it says that you cannot deprive the woman by taking recourse to section 3. Then your lordship will see paragraph number 37. Paragraph number 37 is relevant, madam. The above extract indicates that a significant object of the legislation is to provide for and recognize the rights of women to secure housing and to recognize the right of a woman to reside in a matrimonial home or a shared household, whether or not she has any title or right in the shared household, allowing the Senior Citizen Act 2007 to have an overriding force and effect in all situations, irrespective of competing entitlements of a woman to a right in a sharehold within the meaning of the PWDV Act, would defeat the object and purpose which Parliament sought to achieve in enacting the later legislation. The law protecting the interest, this is relevant, my lord. The law protecting the interest of senior citizen is intended to ensure that they are not left destitute or at the mercy of the children or relatives. Equally, the purpose of the PWD Act cannot be ignored by a slight of statutory intervention. Both sets of legislation have to be harmoniously constructed. Hence, the right of a woman to secure a residence order in respect of a shared household cannot be defeated by the simple expedient of securing an order of eviction by adopting the summary procedure under the Senior Citizen Act. Then your lordship will see paragraph number 38. This court is cognizant that the Senior Citizen Act 2007 was promulgated with a view to provide a speedy and inexpensive remedy to senior citizens. Accordingly, tribunals were considered under Section 7. These tribunals have the power to conduct summary procedures for inquiry with all powers of the civil court.
What happened?
End of that, the court, your lordship will look in, your lordship.
Karnataka High Court, whereby was the direction for eviction was set aside.
No, that is in respect of a shared household, comparing the competing claims of both. Your lordship will see another judgment of the Punjab and Haryana High Court.
Punjab and Haryana is for Punjab too, not for.
But your lordship, since it is a gray area, this court has not entered into that realm. Your lordship may not agree with the Punjab and Haryana, but this is a judgment of Honorable Justice Sanjay Kaul. Your lordship will see the interpretation of the act. If your lordship doesn't accept it, but for persuasive value, I can place all the judgments of
See,
the.
the question is, you can very well ask for maintenance, very well ask for welfare. Maintenance includes even residence.
Done.
But you cannot use that. You may have a place but if it is just one room house where it is not possible to have a cohabitation therein with the other person, then you may ask that for giving an effective maintenance, that person may be removed. But in the friends that you ask the entire, how big is the house?
Plus two, my house. They have heavily abused me.
Why do you
I
want
want to
an
live
eviction from G+2?
I want to live peacefully in this house. The law has said that in all the judgments, my lord, your lordship may not agree today, but your lordship will see from the judgments of the.
I'm
various-
not agreeing means you can very well. Yes, for the purpose of necessity, you can. This is an act of necessity so that you can give maintenance, you have welfare of the senior citizen and as well as the parents. Very well. It's a very welfare legislation to that effect. But the fact that you want the entire G+ to be evicted, you cannot take them.
My son's house, my lord. Have any law said that as a father, I have to look after my major son? Well, that is not the law. If my son has assaulted me, if the son has taken away forcefully my car, have I not have the right to live peacefully in my own house?
If you have only one car, then you can very well ask for that.
One car. I have made a categorical statement. He had
You
seized
can ask
my
for
car.
that car.
I don't
But
want.
for eviction,
My lord, the eviction word is used by the honorable courts of the various high courts, and the honorable Supreme Court has also used the word
therefore
eviction.
the Supreme Court set aside the Karnataka High Court.
No, the Karnataka High Court was set aside only in this case, if your lordship read by word. We can't read a particular paragraph and come to a finding that this.
You read the judgment
No.
now.
Well, your lordship will see, so far this judgment is concerned, there was a conflicting claim under the Protection of Women from Domestic Violence Act, vis-a-vis the Senior Citizen Act. the Supreme Court is conscious of the fact that the senior citizen has a right to stay in that house. But it has said in case of a daughter-in-law, where the concept of shared household comes under the Domestic Violence Act, they said that this Domestic Violence Act, the shared household will have an overriding effect. And if the daughter-in-law doesn't have a house or she was staying in this matrimonial home as a shared household, then the act of the domestic violence will have an overriding effect. This judgment never says that the senior, whereas in the other words, if this judgment has laid that under the maintenance, so when you seek maintenance of the under the Senior Citizen Act, you have the right, the senior citizen has a right to stay in that house and he can ask for.
That is what.
Yes.
You have a right to stay, but if it is a G+2 house, you can very well ask that, okay, ground floor, give it to me.
Examine that. I mean, now
Not
staying
for
in
the
outside.
entire, but not for the entire purpose
Your
of
lordship,
eviction.
there is the
The
day
eviction.
one. There is the day one. I have asked.
Oh, day one, no, this is the third day before me.
No, no, I may withdraw the word eviction because I have used the word eviction as per the various judgment of the Honorable Court. For the time being, I am not using it. Let it be a maintenance. Yes. Let it, the shelter word be inclusive of the word maintenance. Then am I not entitled?
Then you are.
Yes. Yes,
But
for
if
the
the
time.
moment if you are asking for the eviction of the entire thing, it takes a different color. The fact remains that you have houses where you are earning a house rent, you are getting pension, these are not in this dispute. The question is whether you are can evict somebody by.
For the time being, let me use the word maintenance and decide. Then am I not entitled?
Then that is the only thing I want.
My friends will kill me up last day of the vacation. In fact,
No, don't worry. I will all take all the matters and then only write. I don't write before I touch.
vacation, well, they will kill me.
Don't worry, don't worry. Issue notice making it returnable by 11th of December, 2024.
But this person is staying in a hotel. We have given the bills and all. So
Where,
he will not.
where is this thing?
Yes, madam. Bills are there. Page number. Page 51. Sometimes staying in hotel, sometimes staying in friends. I have said that don't stay in a hotel, you'll fall sick. He was the controller of Seba, madam. One of the bill we have annexed at page 51. Fifty-one, 52.
After February 2024?
Staying in I have asked him to shift to a rented place when he came to me. He said, don't stay in
You're staying where?
somewhere in Nunmati, madam. He is staying now. And sometimes staying with his.
Staying at Panjabari.
No, after Panjabari, he has shifted to Nunmati. And I think now presently.
70 the address.
Huh?
At page 70.
That was when
That
he
is
finally.
the order passed by the tribunal.
At that time, now she is staying in somewhere in Nunmati. He fears for his son also, madam. He is now become a refugee. His
No, no,
son.
Mr. Counsel, your affidavit wrong then.
No, no.
Saying that you are staying in Rehabari.
At that point, he is a refugee now, a shifting place. And his son is a gym bodybuilder, I think. That's why he threatens his father, madam. Huh? Not in Gold Gym, not in Gold Gym. Gold Gym has different clientele, madam. Gold Gym, you will find more of matrimonial disputes and all.
Issue notice making it returnable on 6th of November 2024. Mr. H. Sharma appears on behalf of the respondent
One and- one and
2 3. As regards the respondent number 4 and 5, petitioner is directed to 2 ticks, and I have 1, 2, and 3 extra copies of the petition be served during the course of the day. As regards the respondent number 4 and 5, the petitioner is directed to take steps by way of registered as well as usual. Addition to that, the petitioner is given the liberty to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next day. The petitioner herein The petitioner, by way of the instant petition, have exceeded the order dated 19/7/2024, passed by the Department of Social Welfare, passed by the District Social Welfare Officer cum Maintenance Officer. Whereby, taking into account that the petitioner is earning a good amount on account of pension and house rent. The District Social Welfare Officer cum Maintenance Officer was of the opinion that the petitioner could not maintain the said proceedings for eviction of the private respondents. It was also held in the order that the dispute in question was a property dispute and outside the purview of the tribunal. Mr. B.T. Kumar, the learned senior counsel appearing on behalf of the petitioner, submits that the petitioner would not insist on the question of eviction, but it is on account of the maintenance as defined in the Maintenance and Welfare of Parents and Senior Citizens Act 2007, whereby the petitioner, being the parent as well as also a senior citizen, is entitled to food, clothing, as well as residence. The learned counsel submitted that the respondent number 4 and 5 have taken have thrown out the petitioner from a G+2 residence, a G+2 building, which belongs to the petitioner. He submits that the petitioner is residing in various rented accommodations or hotels in order to hotels, in spite of the fact that the petitioner is having owns a G+2 building. The respondents, more particularly the respondent number 4 and 5, are directed to bring on record their stand by filing their affidavits. Mr. H. Sharma shall also obtain instructions in the matter.
Every case that is coming before vacation, before this honorable court, is like a 100-meter sprint for me.
Why?
I see the finishing line, but I can't run it into the stipulated time.
My lord, matter will be kindly for time being possible, my lord.
Why? What is your case?
My lord, the acquisition of land, my lord.
Huh?
Acquisition of my land, my lord.
They have acquired your land, then what have that?
And in the land, my lord, Tata showroom is also situated, my lord, and section 3D declaration already made, my lord. During in the month of September, my lord.
3A, 3B, 3C.
Over means left.
We already complete, my lord. Notification already issued, my lord.
Then what happened?
My lord, and then, my lord, they are coming for a physical possession of the entire showroom and workshop of the Tata Motor, my lord. And I have requested them for some time, my lord. Since, my lord, it will be not shipped within a day or for 1 month, my lord. It will take some time, my lord. Because, my lord, there are a large number of customers also, as well as, my lord, the entire machinery and equipment will be shifted another place. my lord.
When 3A notification came, you knew it.
My lord, that was challenged by the other persons, my lord, of the area, my lord.
Did
And
you
I-
challenge it?
No, my lord, I have not challenged. my lord.
So
I-
you
but
had an option of challenging under 3C?
See, there is a mistake in the notification itself, my lord, because our land is not.
Once the 3D notification has been issued, the effects thereupon is that they can vary the land already vested upon the central government.
My lord, I have
So
not
if it
said
is
that-
the land which has already vested upon the central government, who are you to ask that kindly don't take over the possession?
But I am not on this, on that, my lord. I am not disputing on this, my lord. I have just praying before them for a time, my lord, and in the meantime, my lord, my compensation amount may be determined, my lord.
What?
The-
It has been
Because,
determined.
my lord, because, my lord, Girard Bellu, which was, they have assessed, my lord, which is less than it, it's a commercial land, my lord.
So
That was,
Then he has
it's
to
a-
go to arbitration.
If you are agreed, if the amount has been already determined, then in that regard, you can't go to the competent authority. You have to ask for an arbitration.
Arbitration, section 3G, my lord, there is also matter is pending before the Supreme Court regarding the 3G, my lord. And
As the, Mr. Counsel, matter is pending before the Supreme Court is okay. But the question is whether there is a stay to the proceedings.
My lord, I am also not praying for staying the proceedings.
No,
but I
no,
am
there,
seeking for-
3G, no, Mr. Counsel, 3G proceedings have not been stayed all over India.
Right.
This has been issued, that is another thing. In fact, if you see the judgment of the Supreme Court in the case of Union Territory of Ladakh versus Jammu and Kashmir National Conference.
Right, sir.
The Supreme Court at paragraph number 35 categorically says that merely because a matter is pending before the Supreme Court or for a matter there is a review or a reference, it should not stop any of the authorities, including the High Court, to decide on the questions.
Right.
So how does it matter? And notice has been issued.
Secondly, my lord, we have also submitted an objection, my lord, before the Land Acquisition Authority, my lord. But that was also not considered till date, my lord. And in the meantime, for shifting of my showroom, my lord, I will require almost 3 crore of rupees, my lord. And if the compensation, 3 crore rupees, my lord, which I have.
What is the amount which they have adjusted as the compensation?
Because, my lord, they have, my lord, your lordship may kindly peruse my lord,
How much have they adjudged as the compensation?
they have yet to receive the compensation amount, my lord. I have not received any compensation amount till date, my lord. And secondly, my lord, we have also.
Before the vacation, Mr. No stay business, no stay business. 3E is clear, they can very well take over the possession.
But 3E notice is not served upon. me,
Not
my lord.
necessary, they can take over. Where is the question of notice? 3? Don't come up with all this.
In that
You
case,
take
my lord,
over,
your-
destroy everything, take over the cars also and give it everybody to everybody. Nowadays, Tata has come up with beautiful cars. Take, let all NHI authorities also take one.
Right, so-
But I'll
and
be
only
no.
showroom in the entire Barak Valley and the, my lord, Karti Anglong and my lord, NC Hills, my lord.
Anyways, in the last 2 days of the vacation, one thing good about it is you need to get a notice at least,
My lord.
only a notice.
They will allow us at some time, my lord.
No,
Not disputing this.
no. That I leave it to their best wisdom. Issue notice making it returnable by 13th of November 2024. Mr. Union. No union business. Okay, none appears on behalf of the Union of India. Mr. Each Sharma appears on behalf of the respondent number 2, 6, 7.
I'm for 3, my lord.
The C Bulwai appears for the respondent number 3.
Pass 2 or 3.
Is the G Hazarika appears for 3 and 5. The G Hazarika appears for respondent number 4. 4. Full stop. None appears on behalf of the PWD on call. Full stop. The case of the taking into account that those respondents in respondent number 2, 3, 4, 5, 6, 7 are duly represented. Extra copies of the petition be served during the course of the day. As regards the respondent number 1 and respondent number A, the petitioner is directed to, the counsel for the petitioner is directed to effect service upon the Deputy Solicitor General of India, Mr. R.K. Deep Chaudhary, and upon Mr. B. Chaudhary, who is the standing counsel of the PWD. Pusto. The case of the petitioner herein is that the petitioner owns various plots, owns a plot of land measuring 3 bighas 17 kata in second RS Patta number 5, comma, Dag number 9 and 10. Pusto. In addition to that, petitioners, huh? No, full stop. In the said land, the petitioner have
Constructed three buildings. For the plot of the 19 Katamend.
have erected an RCC building. Have erected three RCC buildings.
That is there, this.
Which is being used as showroom cum office, comma, workshop, comma, washing shed. Full stop. It's an admitted fact that the respondent authorities have how much land is taken from your,
19 Kata, my lord. 19 Kata, 10 Shataks.
where? Where's the 3G?
Radio notification, my lord, is at price.
It is an admitted fact that the respondent
Page 153, my lord, notification.
the respondents
154. start.
have acquired
Serial
the
number
land
223.
of
Page-
the land at measuring how much?
Page 155, my lord.
How much?
155, serial number 220 and 223. That is, my lord, 0.0376 hectare.
That is the only land.
And then, my lord, yes, my lord, and then, my lord, 0.0541 hectare. my lord.
Where?
Next one.
Page 55, my lord, page 54,
The
start.
serial number?
220, my lord,
220 and
223, my lord.
223.
both are agricultural lands.
These are commercial lands, my lord, and
It's,
they are,
it's written in bold and bold letters, agriculture.
my lord, that is not correct, my lord, and I have also annexed, my lord, notification is there also, my lord.
It's a case of the petitioner that
So I am,
admittedly the land measuring 0.0376 and 0.0541 hectares of land belonging to the petitioners in Dag number
Dag number 10, my lord.
10 of Patta number.
Patta number, my lord. Patta number 5, my lord. Second is patta number 5.
Second RS Patta have been acquired under the provisions of the National Highways Act 1956. First, it is also an admitted fact that pursuant to that in terms with, no, also, it is also relevant to take note of that in terms with section 3D bracket 2, Mr. Borua, 3D2, 3D3 of the National Highways Act 1956, upon issuance of the notification under section 3D of the said act, the land vests absolutely upon the central government.
From all encampment.
The learned counsel appearing on behalf of the petitioner submits that in view of the process, in view of the acquisition so carried out, the land of the showroom wherein the buildings which stands on the land would be affected, and it would cause great inconvenience to the petitioners to if immediately the petitioners are removed. Full stop. He further submitted that the petitioners have not been adequately compensated.
And
Mr.
another-
C, yes,
My lord, another thing, my lord, their land is also mortgaged before the State Bank of India, and I have.
hardly matters. Then the State Bank under Section 74 will take that amount. Don't make that submission, yes. Mr. C. Bolu appearing upon the on behalf of the National Highways Authority and NHIDCL submitted that as the land vests upon the state, upon the central government, by virtue of Section 3, capital E of the National Highways Act 1956, the competent authority has can very well take over the possession. And it is statutorily mandated. As regards the question of compensation, the learned counsel submitted that if the petitioner is agreed with the amount of compensation, the petitioner can very well approach either the competent authority if the compensation has not been finalized in terms with Section 3G5 of the National Highways Act, or seek a reference to the arbitration as regards the inadequacy of compensation. He, however, submits that he would like to take instructions in that regard. Taking into account the above, let the respondents obtain instructions in that regard and place it before this court on the next date fixed. First, this court further observes that although the respondent authorities can very well take over the possession in terms with Section 3E, the same of the National Highways Act, but the same be done after giving some reasonable time to the petitioners to remove his goods, to make necessary arrangement. But the same can be done as it is, however, mentioned that the respondent authorities, that this court is not passing any order, but a consideration is only to be given by the respondent. Huh? You have no business.
Item 5, obliged.
Yes, what is this?
My lord, this is a, the comprehension is not adequate. And my lordship come to page 25, CL number 1 is dark number 1 and 86 and 4, pata number 473. Here, my lord, only one Lisa is shown. Then lordship come to the next page, page 26. This is the map of that area, my lord. This is available in the website also. Here, my lord, the reserve land is dark number in the right side, my lord, 378 and 404. But the deputy commissioner, the revenue authorities, my lord, now saying that the entire land and my lord, entire this eastern side is my lord government land.
What?
Actually, my lord, my 6 Lisa land is acquired, and they are saying that my lord only 1 Lisa. And the compensation amount is not based on the market value. It is based on the my lord government value. Lordship kindly see, it will find at page 27 for 1 Lisa 75,000. Zirat value for 1 Lisa 75 lakh. So that is the government value. It is not based on the my lord market.
So what
value.
do you want this court should do?
Like the deputy commissioner to comply with the my lord act, my lord.
Now, has the deputy commissioner passed the award?
Yes, my lord.
If
Alright,
the
but,
deputy,
but I have not received yet.
Aye. Now,
Deputy
if the
commissioner have
deputy
passed, some person
commissioner has
received.
passed the award, isn't it conclusive between you and the deputy commissioner?
There was some communications, my lord lordship.
No,
page-
no,
page
no,
29.
no. How can this rich court entertain such writ petitions?
My lord, not yet, my lord awarded. They have calculated on.
Where?
It is, my lord, page, my lord,
Show
27.
me, how do you come to know that the amount you are going to get?
Yes, my lordship, kindly see page 28, my lord, these are the calculated amount, my lord. GR value statement, my lord, of land. My lord. Page 27 and 28, my lord.
This is yours.
In the left side, my lord, Nawaz Ahmed Borbor.
You are, what is your name?
Nawaz Ahmed Borbor.
The government land.
No, no, this is not a government land, but this is a patta land. They are now saying that this is the government land. That is the dispute, my lord. And, my lord, the amount compensation, the calculated amount is not as per, my lord, market value of the land.
That I'm going to look into. Where are you asking that this is not a government land?
My lord, this is
Yeah.
the, my lord, this is the,
That is not your prayer.
this is there, my lord. Second page is there, my representation. And there were other people, there was a, my lord,
Where is your prayer?
my lord.
That this is not a government land.
I made the prayer, my lord, in the application.
Yeah.
Second application, my lord.
Yeah.
Second page, my lord.
Yes. So let us do one thing. It has been issued to the Zilla Ayuk. Go to the Zilla Ayuk. Where is the prayer when you are coming before this court in your writ petition?
My minister,
That is not your case. Your case is that you want the compensation to be paid as per this act.
My lord.
Fantastic. This amount will be paid. But this will, whether it is paid or not, if it is not paid, you have avenues. This court is not going to touch on those.
No, they
But the
have been-
fact that if it is your Pakta land, but it has been shown as a government land, this court can look into that aspect, only to that aspect.
that respect.
But that is not your case here.
I have also made the prayer, my lord.
Where is your prayer?
the
Show me.
Prayer, lordship, come to page, my lord,
The prayer is in.
page 4, my lord.
There is,
Yeah, my lord. 6, my lord, page 4, my lord.
page 4 is not your prayer. The prayer is at page 17 and 18.
Yes.
But Mr. Counsel,
My lord,
your name is shown against DAG number 1186 of Patta number 473.
47.
This acquisition at page 28 is DAG number 404. How does this have relevance with your?
No, no, actually, my lord, lordship, come to my lord, page 21. This is my lord, this is my lord, Jamabandi, page 21. This 1186 has come from my lord, DAG number 439, my lord.
Where?
Originally, page 21, my lord.
Four? Where?
439, my lord.
Casting partition case number in one of DAG number 439 of PP
439.
number 404.
404.
404. But this is nothing to do with 404.
No, 404, that is, no, Patta number 404, my lord.
Oh, Patta number 404.
Now, my lord, now
Yeah.
they are saying, my lord, lordship, come to page
At page 27 and 28.
27, 28.
This is on DAG number 404. It's a government land
No,
therefore.
they are showing DAG number 404.
This is a government land.
No, no. Actually, lordship, come to the map, my lord. Here 439.
Hmm.
In the eastern side, 404 is not there. Only northeast corner is, my lord.
Where? Yes,
Page number 26, my
404.
404.
How much is the land?
I have, my lord, 1 katha, 10 lisa.
Here only 404, 1186. It has been shown as only one lesser.
My lord. 1186, 1 lisa.
So they have.
But my lord,
One
oh,
lesser from you.
My lord, lordship, come to page 26, the map, my lord.
No, no, no.
439. This is the original map, my lord. Before, in
No,
the eastern
Mr.
side
Pal-
of my lord, 439.
Anyways, we do one thing. We issue just a notice, nothing more than that. But this court is not going to issue that. At the end of the day, you will again land up passing an order that you go and file a reference application. We issue notice, ask them as to whether the award has been passed or not. You know, making it returnable on 11th of November 2024. Ms. D. Hazarika appears on behalf of the respondent number 1 and 2. Mr. H. Sharma appears for the respondent number 3, 4, and 5. As all the respondents are duly represented, extra copies of the petition be served upon them during the course of the day. The case of the petitioner is that the petitioner is the owner of a plot of land at measuring 1 kata 10 lechas covered by dark number 1186 of Patta number 473 of village,
So what part? Second part of the-
village, second part of North Lakhimpur, huh? It's second part of North Lakhimpur. No, Uttar Lakhimpur Sohor Party. Village name of village Uttar Lakhimpur, North Lakhimpur. Sohor, second, no, part 2. Under Moda Lakhimpur in the district of
Now, my lord, it is Naukari.
the out of the said land, 1 lessa of land,
They have acquired 6 lisa. Now they are showing that other land is government. But
they have out of the said land, 1 lessa of land have been acquired by the district administration, by the district administration for construction of the Naukari Road overbridge, as would appear from Annexure 2 to the petition. It is the case of the petitioner that the petitioner have not been adequately compensated. And it is the case of the petitioner that the respondent authorities have made the calculation, without applying the proper yardstick. And as such, the petitioner has approached this court. This court directs the respondent, Mr. H. Sharma, the counsel appearing on behalf of the respondent number 3, 4, and 5, to apprise this court on the next day as to whether any award has been passed.
may I pay a little earlier, my lord? After waiting
I fixed it on 11.
November.
We asked the Chief Justice to change the dates of the vacation.
Problem.
Takes.
Please, my lord, here the petition of user was agreed by eviction notice, my lord, issued by the Karbi Angalang District Administration. The notice is, my lord, at page 101. Order is at 1001 and notice is at 102.
Then
101, this is the order. Respondent number 3 directed the respondent number 6 to take stake. And in view of this order, 102 page, my lord, here notice, eviction notice has been issued. Here, my lord, earlier, being agreed by the same notice dated, same notice and my lord order. Earlier, 2 petitions was filed. And in both this case, my lord, notice was issued and in the interim measure, stay was granted.
Then
This stay, my lord, your lordship, in one case, page 119. Page 119, my lord, relevant page is 134.
now what are you challenging?
The same notice, my lord. Page 101 and 102.
11/7/2024.
Right.
You are challenging here also. Why?
Because, my lord, this is a common notice.
Is it a case that you found out these people now? Or is it a case because nothing has happened for the last 2 months?
It is true, but the question is that without my, if there is no any estimate, only 2 groups, my lord, approach this honorable court and stay order granted. So, against 4,000, this notice is, my lord, affecting 4,000, around 4,000 people.
Okay. Let us keep the doors open for them. Yes, Mr.
I am praying, my lord, at this time, I am praying that similar order passed by your lordship, my lord, please.
I understand that. No, I am saying that in spite of the 11/7, we are in the month of December, October.
Already, my lord,
3 months or 2 months have passed by, nothing has happened. What is the necessity?
because
Mm.
already two stay order is there, therefore,
So
They are-
therefore,
two
there
stay,
are 4,000. We are only having how many? 242. You have already. you have
earlier
come up
in
with
one
another
writ
two.
petition, my lord, 22.
The city will put the same order. Same order, 26/7/2024 orders into us, right?
I mean, the individually, my lord, document.
Yeah, it is given the submit respective representations. The here of the opinion the petitioner should give should be given at liberty to submit respective representation before the respond number 6, bringing to the notice of the reserve that the lands which the petitioner are in occupations are not surrendered. In addition, the petitioner would be at liberty to place that they have applied for settlement over the lands in question which are wasteland. This court grants 15 times time from today for submission of the representative till the next date. Yeah. Now what happened next date? 21/8, what
Sometime in my lord, second week of November, this case is fixed. Second week of sometime, second week of November.
you have the date?
Exact that I can check my lord. But sometime in second week of
Look,
November.
it will notice to issue है तालो कोई भी. It will अपना what is the date fixed for this website? 3718 of 2023. No? It will issue notice तालो को मिला दिबो. बाकी किने हम लोग के API calls हाँ ये नाम भी तो बदलाई दिबो इनको नाम समझी देखिए challenging the order. There is some order. And vacate within 15 days. It's the same order. Page 133 1.
I am like.
Notice है.
55.
May I plead your lordship? Kindly pass over the matter for time.
After vacation, no heavens is going to fall.
Senior counsel.
After vacation, you will get a judge who does not know about the head or tail about this order. You may be in a more better way. Because I have passed the order. I have pointed it out that there is a suppression of material facts. So the next judge who is coming from 21st till 4th may not know all this.
Lordship, the senior counsel in another.
Yes. This is the matter after vacation.
46.
I am alert, I have. 3114 IA.
You are coming against which document?
Notice, my lord, annexure 9 page 74.
Yesterday, somebody challenged this. A person or they have withdrawn it.
Senior counsel KK Mahaprabhu.
They have withdrawn it. Because after the order which has been passed by the division bench on 24/9/2024 in writ appeal 333, what remains? It has been categorically mandated to the record. I can dispose it off saying the respondent authorities shall be bound by as per the order passed by the division bench. That's all. Because you were not a party to that proceedings. It's the same Paikan River Forest.
But my land is different from that, my lord.
Understood, whatever may be, there is a specific direction passed by the division bench that you are to take note of that this is a revenue land or not. You have to consult with them and then do. So as per that order, I think we should close it. Where's the forest? Yes, Mr. KP Pathak. Where is the order passed by the division bench? Yesterday's division bench. 24/9/2023. Ali, है इसलिए यहाँ ऊपर में?
10 or 11. Number 11.
Now that he has withdrawn, but here, those people were earlier parties to the proceedings, no? Now here, these people were not parties to the proceedings.
Yes, sir.
And as such, I think he should be granted the same relief which have been given by the division bench. Where is that order? Hey, without some people see. Isn't that the case? 333. Writ appeal. Kali hai, sir. 333/2024. 333. Hey, the writ appeal 333 of 2024 election, I'm coming back. I for whom?
Yes, for net.
Hmm?
In which state of Assam, madam, it was left out.
It was Sam.
Yes.
Pardon me, it's that's the learned counsel appearing on behalf of the petitioner. Mr. A.P. Pathak appears on behalf of the Forest Department. And Mr. J. Hendik appears on behalf of the District Administration. So there's an application filed for including the state of Assam, represented by the Commissioner and Secretary to the Government of Assam Forest Department. Office at the school Guwahati 781006 as a party to the instant proceedings and party to the accompanying petition, taking into account that there was a formal defect in not arraying the state of Assam. In that view of the matter, this court is of the opinion that the completement of the responder of the state of Assam is essential for an appropriate adjudication of the instant petition of the accompanying petition. Accordingly, this court allows the instant application, thereby impeding the state of Assam represented by the Commissioner and Secretary to the Government of Assam Forest Department, Dispur Guwahati 781006 Assam, as the respondent number 5 to the accompanying petition. The petitioner is directed to file a fresh memo of party before the registry of this court within 3 days, or by tomorrow, by 3rd 3/10/2024. And the registry shall make necessary correction of the course title as well as update the same in the CIS. As there's disposed. In this case, what is your case?
This is that, my lord, my lord, petitioner number 1 and 2 others, my lord, purchased land in the year 1960. And this ancestral land, my lord, 12 acres of land were first left, my lord. That's why, my lord, after the death of the other 2 persons, my lord, petitioner number 1 filed 1 title suit to protect the 12 acres of khas land. And subsequently, these are the legal heirs, my lord, are in that plot of land, my lord. Otherwise, my lord, there is no such type of eviction notice earlier also, because 87 title suit order was there, my lord. And my lord, time to time, my lord, it was also Toji Bahira, that was also paid, my lord. And now, my lord, grievance is there in view of this notice, whether they may also be covered for eviction, as they have the sole plot of land to reside here, my lord. Residential house. Otherwise, they have not occupied.
Yeah, if that be so, why would
This
this,
order will
the
be
division
covered.
bench order,
Yes,
which categorically says,
yes, my lord,
yeah,
it will fully covered.
having heard the learned counsel for the appellant and passed by the order by the, but it made clear that the forest authorities can only exercise its jurisdiction in the RF and PRF lands and not in respect to the revenue land. We hereby clarify that before taking any action against the appellants or similarly situated persons pursuant to the notice dated 36/12/2017, the forest authorities are required to ascertain the land so occupied by the appellants or similarly situated falls within RF and IMAN, and after ascertaining the same, they can take action.
Yes, fully covered. My notice is 99/24. Our notice is 99/24.
6-9, not 9-9. We disposing of the Mr. H. Das, the learned counsel appearing on behalf of the petitioner. Mr. KP Pathak appears on behalf of the Forest Department. The petitioners herein have approached this court challenging a notice dated 6-9-2024, whereby the Divisional Forest Officer Gwalpara had informed all residents residing in the Paikan Reserve Forest that they would be evicted shortly from the reserve forest. The case of the petitioner is that although the said notice dated 6-9-2024 is in respect to the Paikan Reserve Forest, and the petitioners reside in revenue lands which are not within the Paikan Reserve Forest. But there is an apprehension of the petitioners that in carrying out the eviction drive in the name of Paikan Reserve, in the name of eviction from Paikan Reserve Forest, the petitioners would also be affected. It is under such circumstances the petitioners have approached this court. Mr. KP Pathak, the learned counsel appearing on behalf of the Forest Department, submitted that in respect to this Paikan Reserve Forest, there was a notice issued earlier on 6-12-2017, which was a subject matter of challenge in WPC number 8101/2017. The said petition was disposed of by this court by an order dated 2/2024, whereby this court had permitted the respondent Forest Department to proceed with the eviction of from the Paikan Reserve Forest. However, after making due consultation with the Revenue Department as to consultation with the Revenue Department. The learned counsel submitted that in pursuance to the said order passed by this court, the notice dated 6-9-2024 was issued. It has also been submitted that against the order dated 2/2024 passed in WPC number 8101/2017, a writ appeal was filed, being writ appeal number 333/2024. The division bench, by their order dated 24/9/2024, disposed of while confirming the judgment, an order passed by this court dated 2/2024, clarify that before taking any action against the appellants in that appeal or similarly situated persons, the forest authorities are required to ascertain that the lands occupied by the appellants or similarly situated persons falls within RF or PRF lands, and after ascertaining the same, the forest authorities can take any action against only those persons who have illegally occupied the RF or PRF lands. The learned standing counsel for the Forest Department submits that the forest authorities are only going to carry out eviction only in respect to the Paikan Reserve Forest lands, and nothing more. Full stop. This court is of the opinion that in view of the order passed by the learned division bench dated 24/9/2024, passed in writ appeal number 333/2024, the petitioner's apprehension does not survive, taking into account that there is a categorical direction to the forest authorities only to take action, only to initiate action for eviction upon those persons who have illegally occupied the RF or PRF lands. And more so, when the said order specifically mentions about appellants as well as similarly situated persons. Accordingly, this court therefore disposes of the instant writ petition, thereby directing the forest authorities that in taking steps in pursuant to the notice dated 6/9/2024 shall ascertain with the revenue authorities that the land so occupied by the petitioners herein are situated within RF or PRF land, are situated in Paikan Reserve forests, and are only after ascertaining the same, the forest authorities can take any action against those persons who have illegally occupied the Paikan Reserve forest. With the above, the instant petition stands disposed. You file your memo parties, otherwise you won't get that order. Ah.
Today itself, today itself I'm placing.
Yes, I have rest.
Aviator is there, my learned friend is there, they cannot receive this copy because they are absent, so
What?
the aviators, they- their copy cannot be because they are,
They have filed it.
they are absent, by the on behalf of them, he appeared.
Declaring the impugn order passed by the circle officer to be ineffective and illegal. What order?
My lord, page 79, your lordship has been a direction that demarcation and correction, two land, my lord. So
CR is put up today, seen the order dated so and so passed in demand to bring the said matter to a logical kernel, considering the various doubts were carved out in the matter dated demand the edition and the following. Both the parties were heard on their forces persons, represented by his attorney, Vishwajit Barua, and so submitted following documents. Opposite party, Ashok Kumar Barodia, and so, therefore, paragraph deed number, so and so. Right. About the whole number code to the therefore, it is recorded from the file about the villa, about that fact to the land in the number of the like over 305. This was something that was disputed down. View of land of speaks from the portfolio. That people who get out and that would Yes, what is wrong?
My lord, page 56, kindly see, your lordship is made two direction that you also have debarked the land of 205 and record correction because mysteriously the name was deleted of the petitioners from Dag number 205. So that is to taken into consideration of your
Where?
page 56, my operative part, page 50 it starts. Lordship, your lordship does that, my lord. And however, it's observed that the direction of
As regards the other relief which have been sought for, that is for demarcation as well as for correctional records, the same being now being taken up for consideration by the ER. To bring the same within the local remand. This court, however, would observe the land claim by the petitioner in the application arises out of the number 202. Whereas the land which was consumed the right have taken where is the direction?
my lord, when their demarcation conducted, my lord, they forget about the demarcation 205. There is no findings.
Where is the direction by this court that about 205?
My lord, this is prayer 7184 regarding the 205, my lord. So it starts from page 50, my
But
lord.
there is no direction by this court about 205.
Taken into consideration, the circle official.
No, but here there is clear cut
My lord,
205 who are residing. Whereas on field survey, it is come out that dark number so and so are has carved out from dark number 205. Whereas there are other pattadars who have possession over the land. No part of any dark number 2 is under the possession of Ashok Kumar Garodi and others. This is a clear finding.
yes, my lord.
Then what do you want?
I want that, what about this 4 bigger lands of 205 of this petitioner, belongs to 205? There should be findings, my
No, no, 205 has become these dogs. He has clearly mentioned. You see, 202 is of this Garodia,
Yes.
wherein he says that there are two dogs which came out. There is 2657 and 2658.
Yes.
A patra, which is the dog and which is in their possession. As regards 205, there are other people who are in possession. So then,
Then, my lord, this after my lord, your lordship has direct the page para 6, my lord.
yes,
That
what
is
is
why
that?
your lordship says that you will take care of the record correction also. Para 6,
The
page
petitioner's
54.
father was mysteriously removed from the record of rights of the EI and the application was filed by be that as it may, it is a specific case of the petitioner that the petitioner's right is in confined to dark number 5 and such dark which was carved out from the said dark and not in 202, which is subsequently made dark number Iman and presently Iman. So your right is of 202, 205.
Yes,
Then what do you want?
because they claim that this is their land, but now when their demarcation is done, I have stated here and I have given some.
Now, he has categorically pointed out, Mr. Borwar, that these are the dogs which are in possession of other people.
But-
Now, if it is your land, then you have to file an application for cancellation with the patas or whatever may be. Do something to that effect. What is this court going to do?
There should be some observation, my lord, that
Why?
how it is deleted, my lord. 60.
Are where it is deleted, you therefore say that 205 is mine.
Yes.
So under such circumstances, you can file an appeal against this or file an appeal against the insertion of their names. Now you found out that 205 contains these other dogs.
Yes.
Whoever's name is there, their insertion may be right or wrong.
Fine.
So those against them, you have to file either an application. You can't file an application if a mutation has been already done. You have to file an appeal or a 151 application there.
Fine.
But what is this court going to do with this?
Only the procedural defective, I have brought some.
What is the procedure? You were duly heard. All these things have been taken into consideration. What is wrong with this order?
My lord, their land actually in Chitha, if we go to the Chitha, there is no land existed. Actually, 205 is converted. And if record was gone to, my lord,
Your case was specific as regards 205. You said that we have no business with 202.
Correct.
202 is two dogs, which is already there in their names, which is categorically. And they are in possession of 202, those new two dogs. You have anything to do with it? You very well go ahead to challenge this order, or you needn't even challenge this order. You are to challenge whoever's names are inserted in this 205, if it 205 belongs to yours.
all, a portion.
whatever may be, which portion it is that you know that. Check out the map.
Map I annexed, and they have not followed the map. They have manufactured a new map. That is our case, my lord. It should be reviewed. That is why we approach, my lord. They have, in a biased manner, they have conducted everything. And my lord, their land is in on records, my lord. We have gone through it, my lord.
No, this
Yeah,
has been
that-
202 has been done properly.
that-
There is nothing out there.
My lord. Then my lord, they may be fixed, my lord. That may be fixed. I think. So, because their land was not in existence. They said that in 62, they have got, and in 95, they got the settlement. Now they said we purchased.
Is he in possession of your land?
Come out hard or court, my lord. The figure was the caveat, my lord. Not in this case, my lord. And they have not filed the copy.
WPC 3090.
Who filed?
We have filed.
What file?
It is pending, my lord.
What petition is that?
But because, my lord, when your lordship had directed, they started construction on our, which was meant to be our land. Our land is finished, my lord. Now,
Your land has been vanished, so what to do?
how it is finished, I
But
don't.
your land has been categorically said that you have right over 205 and these are the dogs.
Yes,
Then
the demarcation is.
what is required is you have to make those people a party who are there.
My lord,
Why you are making him a party?
because when
Whose
LR
names are there in these new dogs?
when we approach, LR staff says that they are in possession, my lord.
When? After vacation, na? When?
That matter,
Hard of foot, my lord.
in that matter, we already file our affidavit.
My lord, it may be hard to get that 3090.
It has been submitted that analogous petition has been filed by the petitioner, which is registered as the petition number
3090.
3090.
3090/2024, which is fixed on
It has not been fixed, but notice.
notice has been issued. Yeah.
File our
List the instant matter on 4th of November along with the WPC number source.
I have a liberty that I have served the copy, my lord, it should be.
You have filed caveat
Yes, yes.
because the caveat, Mr. So appears on behalf of the caveator, the caveat stands.
Public.
May I please, your lordship? Lordship, with deepest earnestness and with sincere apologies, your lordship, the petitioners could not have been able to take in steps, your lordship. So we pray that a time may be granted to take steps due to inadvertent error, your lordship.
Why haven't you taken steps?
Your lordship, there's an inadvertent error.
Who is respondent number 3?
Lordship, the state chief information commissioner, your lordship.
Why?
So, Lordship, there's an inadvertent error. Your lordship. Absence.
You seem to be not interested.
We are interested.
Then why haven't you taken steps?
Yes, your lordship, we will be taking steps during the course of the day, your lordship.
You can serve a copy upon them.
Yes, your lordship, the
Who
Union of,
appears for the state chief information commissioner?
lordship, the Union of India has appeared here.
No, Union of India can't appear. State chief information commissioner, I think you can appear. These are under this right to information. You can appear. It is seen that the petitioner have not taken steps upon the respondent number 3. And it is under such circumstances, the matter has come before the court. This court inquired with Mr. H. Sharma, the learned junior government. Senior or junior?
Additional senior.
The additional senior government advocate as to whether he would be in a position to take accept notice on behalf of the respondent number 3. He submits that he can do so. Taking into account the petitioner is directed to serve an extra copy of the petition during the course of the day upon Mr. H. Sharma. List this matter for admission after the vacations.
Admission, item 11. Kindly see the last order dated 17/11/21 and then 25/2020. Respondent, my lord, was directed to produce.
Any instructions?
Lordship, though, as for my stated that we will going to file an affidavit, but it's in the BTC area, lordship, just it's you. I think they will look into the matter. Earlier, I have seen lordship for the deputy commissioner also the BTC is here.
Where is the question of enhanced compensation?
The land was acquired in the year 1997, my lord, and compensation paid in the year 2015, my lord. Same rate which was determined.
Huh?
Same rate which was determined in the year 1997, my lord. The same rate has been, my lord, paid in the year 2015. After 15-16 years, 3-4 higher rates, my lord, happened, my lord, in between.
So what is required to be done?
How much
You are
am I-
entitled to additional interest. You are entitled to interest.
Sir, we are entitled to interest, but we have two
Possession
players, sir.
taken when?
Possession, my lord, exact date could not be given here, but 2001, my lord, as per the statement of the petitioners, my lord, I have stated. And therefore, this honorable court directed them to produce the award. When the award was passed and possession, that report I did not have, my lord, available.
Award,
I'm not. I'm for water.
we have taken the land. Award passed or not?
What is,
Where is the award? Have they filed some affidavits.
I have.
Affidavit 7, 8, 9, 10, and 14 filed affidavit, and they have, my lord, admitted my.
Is acquisition done under what provision?
This 41, my lord.
It's done under what provision?
1894. Land Acquisition Act 1 of 1894.
Who appears for the BT? This is in BTC area. Acquisition is done by whom? Hmm? Has the award been passed or not? And when was the award passed? And why did it take so long to get a simple information whether the award has been passed or not? Or you don't have the award. If you don't have the award, you can't acquire. The acquisition has gone for a 6.
In the writ petition itself in annexure 6. Page number.
What?
There is an LA case lordship, LA case number 1 of the 2001.
So how does it matter? Is that an award?
Lordship, it is there. Regarding that amount is also approved.
No, no, no. Whether there is an award or not. Mr. Abba, if there is no award, the acquisition is gone. I'm telling you. Because it is because of the award. There is the transfer of the land. Because of the award, there is a vesting of right upon the state. If you don't have the award, matter is over. We set aside, as you could not prove the award, we set aside the entire acquisition proceedings. We ask you to do de novo, go ahead with the fresh acquisitions.
Now make the instruction, but
No instruction business. Your instruction was asked to be taken on 2021. We are in the year 2024. It's a matter of 2016. Then? Now, from the materials on record, it's seen that this court has specifically directed the BTC authorities as well as the district commissioner. Who does the acquisition? On behalf in the BTC?
secretary then and then.
And have asked the BTC authorities to place before this court as to whether there has been any award passed. Puskar. In fact, the said instruction was sought for by this court by an order dated 17/11/2021. Almost 3 years have passed, but till now, the BTC authorities seems to be unaware as regards any award has been passed or not. It is very irrelevant to observe herein that it is on account of the award which is being passed in a land acquisition proceedings. Statutorily, the land vests upon the state. In absence of an award, there cannot be a vesting of the land upon the state. Under such circumstances, this court grants a final opportunity to the BTC authorities to place before this court as to whether there was any award passed in LA case number 1/2020, 1/2020/01. Footstep. It is observed that if no such award has been passed or placed before this court on the next day, this court shall presume that there is no award. They presume that the LA case number 1/2020/01 have not yet been, is still pending. And thereupon pass appropriate directions. List this matter again on 18th of November 2024. The council, if it is not there, if you want to acquire the land, you can, but then you have to pay. First of the entire proceedings goes for a 6, because in view of section 11A, you are to pass the award within two years from the date of section 6. You don't do it, it goes lapse.
With your question.
Where what is this?
This matter has become infructuous.
Mr. So the learned counsel appearing on behalf of the petition, MH Lascaux, appearing on behalf of the petitioner submits that the petition has become infructuous. Taking into account the above, the petition stands closed. Proceed.
Right.
13 to 18.
Mr. Chaudhary, I put the motion after the vacation. Then I'm not sitting. Yes, what are these matters?
Milord, these are matters where, Milord, initially there was an allotment, Milord, though temporary. If your lordship would kindly come to page 18, Milord,
Of
of WPC 1092 of 17. Same
Nine,
matter, Milord.
9-2.
Yes, 1092 of 7,
Page 18.
page 18.
Yes.
Now, Milord, towards the below, towards the bottom. Subject allotment with Pavitra Kumar Das and Phanindranath Bhuya, Payan, on behalf of so and so. With reference to the above, I am directed to say that Governor of Assam is pleased to order for temporary allotment of 20 bighas of land under DAG number so and so in part 1 of Patkusi BZR under Jonia Moza with Pavitra Kumar Das and Phanindranath Bayan on behalf of so and so Udyog for brick industry for a period of 3 years only on realization of royalty as instructed by government letter dated so and so. So well, now they want to invoke Milord. Actually, in 17 itself, they will rule 18 Milord. My position is not unauthorized. Given,
Then
my lord, there's an interim order.
but how can there be? It's a VGR line.
No, my lord, what I'm saying is, can we say that, my lord, my entry is without any authority of law, sir?
VGR line.
Lordship will kindly appreciate once I have done, undertaken activity for manufacturing brick, would it remain a easier land? my
I
lord?
can't help you because if it is a VGR land, you cannot. You see the Jakpal Singh's judgment, he categorically says those people were allotted. They did everything. Their houses built. Everything was demolished.
Well, only I was thinking, my lord, whether a summary proceeding like Rule 18 can be invoked in a situation like this.
Yes. Because of this VGR land. There's no right. No right. And there is a categorical direction also in that judgment. All state governments should do this. And thereupon the state governments, because this is happened in 1992, Jakpal came in 1996. And they made it very clear that there should not be any.
Matter has been listed after a long time. We also don't have any instruction in the matter. Can it be taken immediately on reopening my lord so that I can have the instruction also? Now, whether they're at all pursuing the activity or not.
Because what is there, otherwise also,
No,
if
no,
you
I
see
want to
rule
quite see
9,
what is following from your lordship.
the rule 95, you see rule 95,
There's a
They
prescribed
cannot be.
procedure.
it cannot be any particular. And there is a provision by 98 by which you can do one thing. You can, if you want to give here, you can re-reserve, you have to put another. In fact, that day I was in Bukakhat, we are having a particular, and there's a subdivisional code being set up. Nice code, isn't it? On the back side of that, there's a good plot of land which we saw it only to be given to the lawyers. But that is still a VGR land. So it is not being able to, we are not in a
The
position to get that
reservation has
settlement.
not been done in accordance with the.
Because there first the AR has to reserve some other plot of land, then you can do this. You have to.
Actually, we don't even have instruction also, my lord. After the vacation, I'll have the instruction.
Mr. Appears on behalf of the petitioners in the instant batch of petitions. The question involved in the instant batch of petitions as to whether a proceedings under a summary proceedings under Rule 18 of the settlement rules could have been invoked. The petitioners had entered into the land on the basis of a temporary allotment issued by the governor. It is seen that the respondent authorities have taken action taking into account that the land in questions are VGR lands, which are not capable of settlement. Taking into account in that view, And let this matter be again listed on 6th of November 2024. Interim orders passed earlier shall continue till then. Kaya order ko dito.
17 and 18.
Respect to 17, you're also going to be allowed to withdraw your vote.
Withdraw.
The term is already over, my lord.
It has been submitted by Mr. So-and-so, the learned counsel appearing on two petitions,
M. Malakar. I'm
both men. It has been submitted by the learned counsels appearing on behalf of the petitioners, named the M. Malakar,
Arpo on behalf of Malakar.
submitted on behalf of the learned counsels for the petitioner. At the term of the Gaon Panchayat, over, nothing further remains in the instant writ petitions. Accordingly, both the writ petition stands closed. The interim order passed earlier stands vacated. Okay. Close on withdrawal.
20.
Somewhat no time to find affidavit because the.
What in this case?
So, we say this is infrastructure. They are running illegally.
Was to implement method is 25. Where is the 25? 25 is where? What is the improvement order?
No, that should be, that should be allowed matters become influential.
Infructuous. Petition. Video. It has been Mr.
On behalf of Mr. Yar.
Mr. ARV is not there.
Some health issues, so.
I can't make it. Why is it infructuous?
Actually, the place where it's located, the fish, by themselves have relocated. to
Huh?
The fish retail market where it was located, against eviction of which it was filed, they themselves have relocated to other place, so further action does not survive.
The council, if it,
Already, but.
Huh?
Already, but. Initially, it was granted for wholesale market. Thereafter, they took out during the time of COVID. But after that, they took out a license for retailer and started the business near the whole. That was not permitted. Then the eviction process was started. It was down to 81. Police force was to be taken out to evict them. In the meantime, they got the stay.
Problem is what should.
in the meantime, they,
They got the stay order.
then
And it went on till date. Well, now they say they are not running in this that particular area. Near the whole. Three 81 is the order dated 25/2020, my lord.
we have it on, when is Mr. ARV coming?
It's on third.
We have it on third. Because at his instance, I can't say, because it is he who has to say that I'm no longer in here. But he is not a person who has signed the wakalat number.
That is right.
Tomorrow, he may be in trouble. Because his senior may say, look here, who is he? You have some councils who do so. It's the matter on 3/10/2024 for instructions.
23.
What remains? What is the challenge? Pursuant to the NIT issued by the general manager for handling.
The defective tender was uploaded.
Huh?
Defective tender was uploaded before EMD was forfeited against that basically.
Now, what is we want? Only for the year that the FCI following month forfeited the honest money deposit. Now, as per the bid conditions, when do you forfeit?
My lord,
Yes.
The petitioner before your lordship is a partnership firm consisting of 4 partners.
No, tell me when, as per your notice inviting tender, when can the bid earnest money be forfeited? There will be a condition.
Lordship.
Where?
Page 30.
You are a petitioner?
Your lordship. What, the clause that they are relying upon your lordship for
Where?
page 31.
Ah.
30. No, 31B.
31?
Lordship has got signing of tender. B, then
All
subclause
supporting
2.
documents.
They have relied on subclause 2.
Where?
At the digital signature card holder. Lordship has got it.
Tender cell 88 ABC. Yeah, 31.
So there is one signing of tender is written,
Submission of tender?
signing of tender.
For signing, there is page 30. Yes. Tell me.
Number 1 is they are then subclause 2, your lordship. They are relying on this clause.
Without signing the iman of any document, iman should be something to produce a proper file. Yes, now,
My case is that here your lordship, in this partnership firm, there are 4 partners. So there is a digital signature card is given to the partnership firm in name of any one of the partners. So in my case, the digital signature card was issued in the name of Kumarjit Dev, one of the partners.
Who?
Kumarjit Dev. In his name, the digital signature card was there. Now, when this notice was issued, your lordship, we participated. We have entrusted one Bablu Ghosh as an authorized signatory to sign in all the documents and participate in the tender process. Now, lordship, he has signed all the documents and he has participated in the tender process. But subsequently, when it was uploaded, your lordship, the digital signature card was used was on that of Kumarjit Dev, another. Now they have rejected my tender on the ground that it is technically disqualified. Lordship will get this at page number page 70. I don't know. Annexure 4. Technically disqualified.
so here you did not produce the power of attorney.
The authorized signatory, he has produced the power of attorney. But in our case, the wrong is that the authorized signatory does not have the digital signature card. The digital signature card is in the name of another partner in lawsuit. But they are,
So in fact, but you have uploaded it with a digital signature.
yes,
If you have uploaded, means it is that person who has signed it.
the tender document, your lordship, that has to be done manually, and then that has to be uploaded. But at the time.
But
of
how do you upload it with a digital signature?
Finally, with the digital signature card.
But
yes.
you have used the digital signature of that person.
Yes. of one of our
Otherwise, it
partners.
cannot be by way of an e-filing. You have used the same digital signature. Once you use the digital signature, did you produce the power of attorney?
The person who has signed, who has been authorized to sign, he has produced the power of attorney. But the digital signature card, he has no power of attorney because he was not given the power of attorney, your lordship. The power of attorney was given to Bablu Ghosh, who has signed all the documents, who has done everything. But
I'm asking you, did the power of attorney holder, was the power of attorney at all placed before the authorities of Bablu Ghosh
Bablu Ghosh.
and not of the digital signature? But you use the digital signature and the digital signature person did not produce the power of attorney. You also say that the digital signature card holder did not sign the document.
Yes, it's not the.
It is, however, it has been uploaded with his digital signature and as such, you could have rejected it, but you could not have forfeited.
Forfeited. Because subclause 6(2) provides of refund of earnest money, your lordship will get it. 6(2). earnest money is there in the same page, your
Return
lordship.
to all answers are within a period of 15 days from the date of disqualification and not whether you are 15 or this. 30 days. Now, where is the order? Include order?
Include order, lordship would get at page 78,
70?
the last
28.
73, and then the appeal that was disposed of. 73. Page 73, the first order, then I filed an appeal also. Paragraph 2 will be read.
Okay. You are to get the money. And he is not willing to pay. Well, we'll have it some other day. You are not in a hurry. You've got lots of money. We'll have it next year. This year. Okay. List this matter again on 3rd of December 2024, on which date an attempt shall be made to dispose of the report.
25.
Yes. Affidavit file.
Malad, yes.
Then what it means?
We have given our response also.
Huh? What are you challenging?
Malad, that panel order at page 79, Malad. Case, my lord, regarding the contract, the municipal board, in understanding all the difficulties, canceled the contract, cleared my bill, my lord, and they are about to release my.
So
money.
your earnest money.
Only that part were, all bills were subsequently cleared, but subsequently it was cleared and it was cancelled also.
So your earnest money has been taken away.
On the top of it, my lord, further is the penal order saying that deducting earnest and unmanaged security deposit, I have to pay another 16 lakhs, my lord.
You gotta stay.
No, my lord, still was not.
No stay.
Page 80, last part, my lord. Penalty of 57.33 lakhs was imposed. Out of that, the deductions were made and paid that 16,37,000 is still to be paid by me.
Now what happens? You are challenging this.
And also,
Now, how will this court entertain or decide
my lord,
whether you have completed properly or not?
that will be revealed from the documents that are available. What they are saying in the penal order, that is also, my lord, page 17, Lord of kindly see. They have admitted that they could not hand over the possession of site A.
Whether possession has been handed over or not, where is your agreement?
Contract agreement is 34, my lord.
No arbitration? But how can this court decide?
Well, that's why I'm trying, my lord. Lord should kindly see for a
No,
moment.
there is otherwise proceeding.
Here, Lord should indicated last occasion, my lord. But here, Lord should kindly see, it is not a non-payment of bill, my lord.
It's not a non-payment of bill. It is a bill that where they have illegally taken that. You want your recovery of your earnest money, you want the recovery of a security deposit, you want to set aside that particular document on the basis that this has been done in this way. But how can this court decide that as to whether the completion was done in accordance with law and as per the tender conditions?
Well, yes, only issue here is that, my lord, the work was to be completed in two parts, block A, block B. There is no dispute regarding block B. Block B have completed, handed over. Now, this is also an admitted fact that when the construction was going on, the board was continuing their office from block A. They have admitted the fact. Then, my lord, Lordship may kindly see for a moment, my lord, the board admitted everything and my lord appreciated everything, page 73. 73 for a moment, my lord. The order has been passed, my lord, all of a sudden, my lord.
What is your ground for initiating writ?
This order is absolutely arbitrary, my lord. You know, instrumentality of state cannot, my lord, that ABL International I'll be placing, before your lordship, my lord. Now it is settled that even in a contract matter, my lord, state cannot, instrumentality of state or state cannot have arbitrary, my lord. At any stage, even for recovering financial dues also, it is maintainable. And that
The
is
recovery of dues will be maintainable, but how?
in a writ proceeding, my lord.
When?
Madam?
When? When it will be maintainable?
When there is no disputed question of fact,
Please.
correct,
Yeah.
my lord.
Now the question as to whether you have completed properly or not, within time or not, these are not, are you admitting, Mr. Dutta? There,
Your lordship, just see
That's why,
their
that have,
contention at page, my lord, in paragraph 15, my lord, what
well,
they have said.
I have enclosed,
because I remember, when this matter came up before this court, I asked Mr. Dutta first wanted to argue. Then nothing, then I say, let us go by the question of doctrine of non-prevalence. Then he immediately said that I'll filing a reply. Don't spoil your vacations by getting a dismissal. I request, huh?
Your lordship sees what they have stated in their paragraph. They say, my lord, they could not complete due to escalation.
no, but that is,
Understood. Therefore, these are not the questions which this
no,
court.
that is not our case, my lord.
This is absolutely within the realms of the contract. If there is no arbitration, then you have to go and file a suit. This court can only give it at one thing. This court can give you the period during which this is there, 14 would not would come into play and the limitation is taken care of. Otherwise, nothing. At the end of the day, you will ask that only after 2 years.
But on paper, municipal board resolved the dispute, my lord. They say that, okay, we understood, we are cancelling, we are paying you a bill.
That is a question of evidence.
No. They have
Evidence.
documents, my lord. Now, here, my lord, in the proceeding,
Are they admitting the documents?
yes, my lord, that's why I said that, my lord.
No, they are not.
Not correct at all. My lord, why you
Well,
could not say we have stated that due to the clauses given in the contract.
Nothing.
No.
No, nothing. This is a case for dismissal. Anyways, don't spoil
Well-
your vacation. At the request of the council for the petitioner matter we listed, there will be a kinder judge in between on 28th of October.
I think could have been disclosed of today also.
No, don't spoil it. None appears on behalf of the petitioner. So it is seen on the earlier occasion also none has appeared on behalf of the petitioner. Seems the petitioner have lost interest in the proceedings for which the same stands dismissed and non discussion.
27. But I want to do this with on respect on them.
Withdraw. You got the money?
This settlement is.
Mr. J. Ahmed, the land counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant petition according to the petition stands closed on withdrawal. Ms. So-and-so appears on behalf of the PWD and submits, and this is submits, place the paragraphs comments which are kept on record and marked with the letter X.
Hello.
Twenty-eight. Twenty-eight.
This is in view of that judgment. BP Bora, what is that name? Bimal Bora. Delivered the judgment now. This is the case where he's covered by that judgment. What is the name? That is why he's not appearing. No idea. It's covered by my judgment. After 50 ration cards.
Concord not, he was there, mother.
No, the matter went to division bench. Division bench upheld that judgment. It was dismissed.
I have to ask Mr. now. That editable number.
None appears on behalf of the petitioner. The issue involved in the instant petition is covered by the judgment of this court in judgment wherein similar petitions have already been dismissed. Just taking into account the above, the instant petition also stands dismissed. To report it in report is day. This must be in the month of
Twenty-nine.
2020. Yeah, what is this? For this matter, you are going to give. We then allow the repetition. This is under the AGST Act. We allow them.
The laws have done, that is all the other repetition that we have challenged
That will be subject matter of that.
for the
But
same.
here, these payments were made as a condition precedent for entertaining the revision petition. And there are many judgments to repair. If I was, that day I was looking into a judgment in the case of Sushindra versus Union of India. This is a judgment by Justice Bharucha, where the payment was made in respect to filing an appeal under the Central Excise Act. And the question arose as to whether section 11B would apply, which is a refund, there's a processing. Supreme Court said nothing doing. This is only for the purpose of entertaining the appeal. And as such, you are bound to it. Allow, this is not the way. What is this? Amount was paid as a condition proceeding. Where is that? Yeah, this type of institutions. See, at last, your department is not concerned, we are more concerned. I would have understood if it was a case of assessment, it's a case of refund. Not a case of refund. It's a case of returning back the amount which had to be pre-deposited on account of filing the revision application. There's a difference of that.
But also in the internal order, it was stated that the adjustment should be made after making the reassessment. Then lots of the pre-deposit amount will also be.
No, you cannot touch that. Pre-deposit is different, therefore. Recently, I passed one order. Oh, yes. It here with. Take it up at 2. Find out this is the judgment. So many judgments I keep on giving, I completely forget which case I used this judgment. Yes, 2016, 11 SCC 808. Take out the judgment, we'll see at 2 o'clock. So there is a difference between both. Here, if it is based on the condition of precedent for entertaining the revision, you cannot make it all. You may pass whatever order.
31.
Thank you, Lord. Lord, the pleadings are complete. And that, Lord, on the last occasion, was the respondent who sought an accommodation. Yes, that is. Yes. And in response thereto, my lord, we also filed a reply yesterday that has been brought on record. 6, 7, and 8. Ours were filed yesterday. It has been brought on record with your lordship's permission in the morning. (27/9). It is dated 27/9, but yes, additional reply because they have filed an additional affidavit in opposition.
What is the case about?
Well, my residence is located in the Fancy Bazaar area. And there, the private respondents are carrying out a construction on the adjacent plot of land. Because of it is my case that because of the kind of construction that they are carrying out in the land, damages are being caused to my residence. I file a complaint before the municipal authorities. Municipal authorities summon both the parties for a discussion. Discussion takes place 5th of November 2022. And there is an agreement, sort of an agreement is arrived that in case the construction is causing any damage to my residence, the private respondent should be taking care of it and they will remedy the damages. Thereafter, nothing happens. They don't undertake any such kind of work and they continue with the construction. I come rushing to the writ court and thereafter they take some measures. Some of the damages are taken care of. I mean, those are remedied. My consistent approach to the municipal corporation remains that there has been violation in the construction plan and the construction should be looked into by the municipal authorities to ascertain whether or not the violations are the reasons for the damages that are being caused to my things. That is not done till date.
That is the case.
That is the case. The respondents come, private respondents come. They also admit that there are damages caused to my residence, but they say that these are because of the very old structure of the house and the natural decay that the time has taken its toll on the house, that therefore the damages were there, but still as a goodwill gesture, we undertook the repairings and these are the repairings that we have done. And the last affidavit that they have filed, an additional affidavit in opposition, they contend to say that we have also provided additional monetary relief to the party. And that we have clarified in our reply that it is in relation to a different kind of transaction, which has got nothing to do with the damages that has been caused to the premises and the responsibility that they're going to undertake. But as on date, my
But
lord,
Mr. Doctor, the thing is, if there is any other damage between both of you, it's a subject matter of a civil court. But
yes,
if it is the inaction on the part of the GMC
yes.
in looking into the plan by which it is being affected, or in a plan that approved plan has been given in such a manner, which is not in terms with the bylaws or the regulations, then obviously a writ would lie.
That is the only aspect remaining for consideration, my lord, in my humble submission. As on date, my lord, because the fact of
What is the stand of the GMC?
they have taken a very casual stand, I should say, my lord. Entire affidavit is running into no comments, except for stating that somebody has carried out some construction and that now that the construction has come up and the damages have been remedied, so there is no chance of further damages being caused. That is
But whether it is as per the building bylaws,
nothing. There is no response on this.
where is the affidavit?
Their affidavit, your lordship will find at pages 116, starts at 116. and they refer to one letter written by somebody of a different entity, and thereby they want to justify that that in the construction there is no violation.
What are the violations you are saying?
But it is a large scale violation, my lord. My house has been damaged, the floor has been damaged.
No,
boundary
that
wall-
is not a violation.
No,
The damage
then
which is being caused to you is again, I'm telling you, it is
is
a
the
interparty
construction.
between you and the private respondent. But what is the violation to the building bylaws?
So that I have said on affidavit that they have constructed they have carried out the construction. They have made a double basement parking in the ground level. Therefore, and that has been done without creating appropriate provision for retaining wall. As a result of deep digging into their soil, my lord, because the lands are adjacent and it is just near the river bed. I have said that because of the deep digging done on their soil, my boundary wall has collapsed and the resultant damage has caused in my residence.
So what is the violation of the building bylaw?
I have said that, my lord, this construction of double basement is not permitted anywhere in Fancy Bazaar area. It has not been done in.
No, is it permissible as per the building bylaw?
But
There's a difference between them.
that aspect has not been clarified.
No, where is your allegation to that effect? That there cannot be a double basement as per the building bylaws.
So I have only said that this kind of a construction has not been permitted in Fancy Bazaar area.
No, forget about the fancy weather. We are not, the building bylaws is not for fancy
No,
weather.
yes. But there are zoning regulations, my lord. There are zoning regulations, and I have said that-
But whether it is in violation to the zoning regulations, that not to have a double basement.
that I have not specifically
Then
said that.
if there is no violation as regards the building bylaws, then any dispute between you and the private respondents is before the civil courts.
So my only relief that in my respectful submission remains to be considered by your lordship as on date, because the building has also come up. It is not because I came at the very initial stage saying that the construction should not go forward. But there was, since there was no interim order operating, my lord, the construction has come up and the building is there. So my only prayer that remains to be considered by your lordship in the petition is that whether or not to direct in the facts of the case, whether or not to direct the GMC authorities to carry out an inspection as to ascertain whether this which I say that it's a deviation of the building plan, that double-storied underground construction, whether that is in accordance with law.
But first you have to show that it is not permissible as per the building bylaws. If you don't show that, then why should I ask the GMC to look into it? First, I have to ascertain, yes, this is the law which is there. And because of this law, there is nothing being done. As such, I will ask them to inspect. But if you don't show me that there is a building bylaw which prohibits that the double basement or cannot be there, then how can I help you?
But yes, that statement is not there, my lord. That statement is not there that it is not permissible under a particular bylaw. That statement is not there. But
Okay, but if you are saying about a violation, we can further extend the scope to say, allow you to permit to show the building bylaw, which is the particular building bylaw which stipulates that.
that your lordship may kindly consider granting.
Huh?
That your lordship may consider granting me, my lord, because
That is the only question, Mr.
Yes,
Doctor. There is nothing else.
because
Both of you are fine. Otherwise, go before the civil court. Whatever damage is gone, it's gone. Isn't it, Mr. Nayak? Or you have to say that there is a building violation. Paragraph? That a building permit is issued on the basis of a planning permit issued and only after thorough verification of the site and all the things are specified. I think that the ground floor slab is completed and there lies no possibility of digging in the campus of IMA any further. In addition, also stated the opponent, all precautionary measures are being taken for construction work. Unless you point out which is the building bylaw which has been violated.
No, my lord, my case was premised on the sense, in the
One zero two. Where? Yes. No, there is a 102 is the no objection certificate. Oh, yeah, this is 103. Okay. Tell me. You are showing what? Upper, no. Where? Upper ground floor, lower basement floor. So here a permission has been granted in that. No, that is as per the building permit. Now the question therefore he has to show that that is not permissible as per the building permit, as per the bylaws or the regulations. That is the question. Otherwise, why should this court entertain this type of petitions? Huh? Then, Mr. Doctor,
my lord, that I must admit, my lord, that is not in specifics. That is true, my lord. I cannot deny that. But my case, that has been put up before the honorable.
your case is actually an inter-party dispute between you and the private respondent. You are only troubling Mr. Naik.
Nayak has been, so he has been very evasive in the responses. my lord.
No, he has made it very clear that this is it. We have made a scene out there. They have already constructed the ground floor, the total. There is no violation to that effect as per the building permit.
My lord, one thing is clear, my lord, from the pleadings and counter pleadings, that there is a construction, and because the private respondents are also not to be understood as a Samaritan, that for whatever is happening in my residence, they will come up and they will take the remedial course. They are admitting to the fact that whatever has been damages caused, they are making good attempts to remedy those damages, repair those damages. Unless and until it has got some nexus with the construction carried out on the adjacent plot, my lord. Because it's a
They are
commercial-
doing out of fear because this court may do anything. But if I further keep on deliberating with you, the fear would erode very soon. That something will happen, this construction is going on, by chance this court stays it will cause a huge financial burden upon them. It is because of that they are doing it. But the moment I dismiss this petition, matter ends. And asking him to giving you the liberty to go to the civil court, then they will say, okay, let me construct the building properly. And thereafter we'll see.
The building, they have already brought up the building, my lord. Building is in existence now, and the stance taken in the affidavit is that since the first floor and second floor casting is done, so there is no scope of future damage in the adjacent property. That is their statement. But what I could understand from the
Mr. Dotto, overall, whatever you are saying is a case falling within the civil jurisdiction. This court has no business out there. It is the interplay
only
between them.
paragraph.
It is JMDA or the JMC having entertained the dispute and trying to settle it without any problem is now in troubles out here by way of a repetition.
No,
Isn't that, Mr. Nayak?
possibly,
Huh? Sometimes doing good also. Huh? Now, first of all, what is the commissioner going to do? Just for example, if he puts it also an affidavit by which it's tripartite, he has no business to do that. As per the High Court, the act as well as the rules. They can't, the commissioner cannot impose upon conditions both are there to that effect, that you are going to provide the adequate relief. Where's file?
No, no. No, but that is another aspect, Milord. BB Associates is nobody in the scheme of things.
But
It is
but
between other
Mr.
parties.
Datta, the question is very small,
I understand. Milord.
very small.
Well,
Unless you show any infraction
Well,
on the part of the
let me
service.
answer to this, Milord, after the vacation.
It is only a case of environmental damage with so many pages in respect to an issue. Okay. The request of Mr. S. Datta matters and is going to be listed after vacation. We don't require data.
Well, obliged.
Pending item 29.
Yes, did you see the judgment? Where's your order for depositing?
My lord, we have page 94,
Huh?
96, my lord, while admitting the.
Consideration of payment of 25% of the disputed in one under section. 2 of the- Is it on the VAT Act?
VAT Act.
Me VAT Act on the website. Where's the 2A? Is it an amendment? Where's the provision?
But revision by, your lordship is looking for revision, but revisional powers.
The revision is okay. Where is 82 2A?
Yes.
I don't have it in my book.
My lord.
So this is under 82(2)(a), 25%. It's 20% here. Or 25%. Now he has deposited that. Pursuant to the order passed by the division bench. Now, initially his appeal was dismissed on the ground of not making the pre-deposit. Now, therefore, once he won the case, then you have to refund the amount. Because this is not a part of realization. Huh? Really? Where? 138. Which paragraph? In view of the above, the assessment orders passed by the so and so have been set aside. The dealer will submit the original of 9 Form C as a directed to pass fresh assessment order for aforesaid order of receiving this order in view of the observations and directions. So then, that is what 138. Dealer had deposited on different dates against the liability raised under the VAT. Is this the amount?
This is my lord.
That
What is-
liability is different.
What has happened, my lord? It was trade in course of interstate trade and commerce. When it is interstate trade and commerce, the dealer has to pay CST, my lord. CST was deposited. The assessing authority assessed it as local sales, my lord. That is how it was converted into VAT. When it was converted into VAT, my lord, the deposit which were made against CST were brought into the VAT account. And after this revisional order, the revisional authority says whatever deposit has been made in this VAT account now should go back to CST. And after reassessing the CST amount, if there is some excess deposit, it will should be refunded back to the dealer.
But you are not asking that refund.
I am not asking that.
That is not the refund he's asking.
No, my lord. No, lordship.
He's asking only the amount which he has paid as per 25%.
25%.
Not to pay this. my lord. Why you asking this 6 lakhs, 6 crore,
My lord, this
36
is the,
lakh?
if your lordship comes to my para 12 of the writ petition, my pleadings, my lord.
What?
This is the total same, amount is the same, my lord. But I am not.
Now, how much did you deposit
My
as a
lord, 6 crore
pre-deposit?
36 lakhs. 6 crore 36
No,
lakhs.
no, no. You did not deposit 6 crore.
Lordship, there were several assessments, my lord.
See, this is in consideration of the payment of 25% of the disputed amount of tax and interest under the Iman. How much did you deposit?
My lord, in a total, my lord, 6 crore 25 lakhs. This is the amount. The total in respect of all the assessment years, my lord. The assessment years were for 5, 6, 6, 7, 7, 8, and 8, 9. So all for respective assessment years, my lord. In one assessment years, my lord, 25% was deposited. In respect of certain assessment years, we approached the division bench, my lord, where division bench permitted some relaxation from 25%.
I'm only concerned with how much was the pre-deposit.
The total is this, my lord. Is paragraph 12, my lord. Stated.
Paragraph?
Paragraph 12 on my writ petition, my lord. Eleven and 12.
No, this is not your case. You have made a different case before me. You have all along saying about this amount. that this 25% which I have disputed, deposited, that should be given. Isn't it his case? He has been
Lordship-
making that submission.
Yes, Lordship,
But that is not 25%. Are you saying that your amount is just 6 crores is only the 25%?
25%. That is the 25% pre-deposit in respect of all the respective assessment years.
It can be.
If your lordship peruses,
Show me the assessment orders.
my lord, the relevant portion of the assessment orders, lordship will find. My lord, page, it starts from page 25 onwards. Because
Where is the assessment order? Assessment order 15/7/2000.
Yeah. Now demand, lordship. Page 40 will be the demand of the first assessment order, my lord.
In this case, it is 65 lakhs only.
Lordship.
Then
Then thereafter, my lord, second assessment order is, my lord, it starts from page 41 to 57.
this is how much? 2 crores.
Yes.
So did you pay the entire amount? So how much was the total amount then? If it is 25% is the 6 crores, the total amount has to be more than more than 24
For the
crores.
subsequent assessment years, it was relevantly high demand. Right? If you
Then it must be 24 crores then. Where is it?
some. Something around 39. If your lordship comes to page 73, my lord.
No, here we can only direct them to carry out the reassessment, nothing more than that. Question of refund does not arise. Because if that is the question, the 6 crores is not the pre-deposit, it is on a different scale. One has to take up the matter.
My lord, then, my lord,
Total amount is 41 crores.
41 crores.
And then
41 crores out of 25% of the 41 crores will come to 10 crores, my lord. We could not deposit that amount. That is why we approached the division bench. Division bench allowed some relaxation. And now the cumulative total of the all the pre-deposits amounts to lordship this figure, my lord. 6 crore 36 lakhs 47. This is the figure, my lord. That is why in our notice also demand for payment, my lord, we have quoted the same figure. If your lordship peruses,
now all these assessment orders have been set aside.
set aside by the revisional authority.
Now what is to be carried out?
My lord, revisional authority directed the assessing officer to redo a fresh assessment because now revisional authority holds that it was in fact trade in course of interstate trade and commerce. So once it is trade in course of interstate trade and commerce, again, whatever
And when was the order passed? Divisional order?
revisional order, my lord, was passed on 26/2/2020.
Now, then they have to give effect to that order, not a reassessment. It's,
Not a reassessment.
it's only a giving effect to
Giving
that
effect.
order. Now, how long, because as of now, there is no assessment order. If there is no assessment order, and if you don't carry out any assessment pursuant thereto, no, forget about that. What will happen to the limitation? It will go as per the self-assessment.
Have approached the Assam Board of Revenue.
No, forget about that. Board of Revenue that did not, you have approached this court has issued notice, that is a different thing. There's no stay. How do you take care of the limitation? How do you take care of the period prescribed? Can you have it after 10 years? Then,
Under the remedy that was available, we have approached the
you approach whoever it is. It is your fault. You have not been, the government has not been able to appoint a chairman or board any person that is there. It is a different case. This court has not even stayed that proceeding orders. It's a different case. But the fact that there was a direction to pass fresh assessment orders, if it is not done within a period of time, wouldn't it be barred by limitation? Then what will happen? What will be the next course of action? COVID would not help. COVID, Mr. Counsel, COVID would not help because here there is no provision. This is under the 2013 Act. And this is not the 2017 GST has come. So no COVID.
And also the limitation that was granted by the apex court, that will cover the limitation part. And on that basis, logic, we have approached the statutory tribunal. And but due to the lack of quorum, the matter has not.
Forget about that. I'm not on that. The question is, how will you take care of your limitation? A limitation which have been given by a statute, it can only be extended by way of a statute or by an order passed by the court. You go to the Supreme Court, file an IE out there in that the Sumoto 3, then you may get some order, it's a different thing. Otherwise, how do you take care of this? If there is no assessment being carried out thereafter, then there is no assessment, matter goes, he goes as per the self-assessment. How do you take care of that? No, it is not going to happen like this. Mr. B. Chaudhary, the learned counsel appearing on behalf of the Forest Finance and Taxation Department, had submitted an instruction issued by the Commissioner of Taxes to the effect that there has been no reassessment made as per the revision orders. And as such, without the assessment orders being passed, the question of granting any refund does not arise. Full stop. It is relevant to take note of that in the instant proceedings, the petitioner initially submitted self-assessment. Full stop. Subsequent thereto, it was an audit assessment or what? After self-assessment?
Audit assessment.
An audit assessment was carried out, wherein various assessment orders were passed in respect to various financial years. These assessment orders have been set aside and quashed. And thereby directing the authorities, the assessing officer to carry out, to pass appropriate orders, giving effect to the revisional orders. The revisional orders so passed, dated 26 to 2020, have not yet been stayed by any proceedings, in any proceedings. And as such, the respondent, the assessing officer, is bound to follow the order dated 26 to 2020, giving effect to the directions passed therein. Firstly, this court had put a specific query upon Mr. B. Chaudhary, the learned standing counsel. That taking into account that these orders, taking into account that giving effect to the orders, giving effect to the order dated 26 to 2020 and passing assessment orders, press assessment orders. Being not done within a particular period as to whether the same would not be contrary to the provisions of the Assam Value Added Tax Act 2003. which categorically stipulates which categorically prescribes a period within which the order of assessment is to be passed. Mr. B. Chaudhary submits that he would take instructions in that regard. List this matter again on 5th of November 2024. Will you dispose it of on that day? And you come up properly with that, how much you have paid in.
Madam, there is a.
Come up with a proper chart.
Yeah, madam, there is an admission about them by them and madam, there is a annexer, they themselves have admitted. It is 6 crore 36 lakhs. Yes. See, madam, there is an.
The entire pre-deposit.
They are naming it as security deposit, but it is the.
No, that is not.
Any
In
case, I
addition to
also-
that, no, we'll take it out on this judgment, Union of India. I think this will help you.
33.
Yes.
Here, my lord, we have challenged election notice, my lord, that is, the lordship will find that page 27.
You have filed an IA
IA has been dismissed. No, sorry, IA they have filed
for what?
for vacating the interim order.
What happened?
Dismissment. Sorry,
Impugn order
sorry,
passed
IA
by
has been
this court
disposed of.
in connected so and so.
IA has been
Stands
allowed.
modified, huh?
IA has been allowed.
So in the interim order is not there.
Not there.
Requisition one court, I what is your case?
Case is that, my lord, the private respondent has obtained an order, my lord, in WPC number 5715/22. That is, in the notice itself, it is mentioned, my lord.
Then
My lord, there, I was not the party.
Then
It was disposed of directing the person concerned to evict from the land, government has land.
Hmm.
And accordingly, my lord, the notice was issued by the circle officer. We have come against this officer, my lord.
you have come against which order? Where is the notice?
Yes, that is page 27.
Page 27. With reference to the so and so and under rule 18, it is hereby given to you that you are illegal. Directed to vacate the land in the. Then what is your case? Why didn't you approach the circle officer?
No.
It's a government land.
Yes, government land.
Then
Government land. But we
you are
have,
asking for settlement.
yes, we have for settlement, we have approached, but while giving the dag and patta number, we have given the wrong dag and patta number.
Fantastic.
In
Then,
the
and
Vasundhara-
anyway, you don't have a right to be in possession of that particular land. Then,
Yes.
now,
And
you,
my-
till now, you have not been thrown out in spite of the interim order.
Everything gone, my lord. Gone. After when the IA has been allowed, my lord. I
You
have been evicted from that.
Then what you
place,
have? What do you mean? Instructions.
In fact, also, but whether, my lord, I was not the party and direction has been made.
Can't help you.
Yeah. And then,
That
we have
order
filed
is
that one, against that order, we have filed writ appeal. All matter may be, my lord, refer to the writ appeal court that, because writ appeal is pending.
Against this or
Yes,
IA.
against the order of the writ petition which they have got,
IA,
not IA. The earlier writ.
that is a different thing. But here nothing survives, not to evict.
Of course, I have been evicted.
Okay, the Mr. B. Sinha, the learned counsel appearing on behalf of the petitioner submits that that pursuant to the eviction vacation of the order dated 24/7/2023 passed in the instant writ petition. The petitioners have already been evicted. Taking into account that above, nothing survives in the instant writ petition for which the writ petition stands closed.
Public.
34.
Yes, what is this?
I filed this repetition that my predecessor in interest was the owner of 101 bighas of land.
Who?
My predecessor.
Then what happened?
Then after coming into force of the Assam Sealing Act, my 50, around 52 bighas were declared as sealing surplus. And I was possessing 48 bighas of land around. I was cultivating over the same. Thereafter, what happened? During the settlement period, my land was converted into wrongly recorded as government khas land. I preferred several applications, but nothing was given.
No, did it go in sealing?
Yes. 52 bighas went into sealing. I had 101 bighas.
Then?
52 bighas went into sealing, and I was possessing
Taking
40, around
permission
48
for-
bighas.
So, no, where is that order by which it only 52 bighas went and you had 101 bighas?
That I have filed an RTI application, prepared an RTI application, and at page number 25, they replied to that RTI application.
What did you ask for?
Page number,
How many bighas of land was standing in the name of Nasir Ali Bepari,
that was my
son of Bapu Sheikh? Who are you?
I am the successor in interest of Nasir Ali Bepari.
In the name of Nasir Ali Bepari, Bapu Sheikh in the revenue village. Now, what are you asking? Yes, what is your instruction? Oh. Notice has been issued. Oh, recently. Mr. B.J. Talukdar, the learned additional senior government advocate submits that the instructions have not been received in the matter. Taking into account the above, this court fixes this matter again on 25th of November 2024. In the meantime, with the honor before the next date, the respondents are directed to bring on record their stand by filing the affidavit. So it is made clear that if the affidavit is not filed, the court shall presume that the respondents have nothing to oppose, and this court shall proceed to dispose of the petition on the basis of the materials already available. You have extra copy?
It was served.
It is-
I've served.
Extra copy of the writ petition. You serve another one.
35. Volumes.
Yes, what are these? 1st of October, some affidavits filed. What is this? Who has filed this?
That's on your last date, if your lordship will recall. The ASI had been directed, paragraphs 8 and 9, your lordship may see. Okay, this is ASI had filed of the last order. The court has also taken note, I'm reading, paragraph 8, of the submission of Mr. R.K.D. Chaudhary, the learned deputy SGI, who appears on behalf of the Union of India, as well as the.
You filed the affidavits?
Well, the last two lines are important. He submitted the affidavit on behalf of the Archaeological Survey of India has been sent to Delhi for vetting and will be filed shortly. The importance of the said affidavit is well taking into account the additional affidavit filed by the petitioner, bringing on record certain information obtained from the ASI under the Right to Information Act. Taking into account this matter again. So, well, on the last date, if your lordship will recall, I had filed an RTI and I'll take your lordship, but they had in the RTI said, we had said these are the 6 monuments. They have said in Kamakhya, there are 17 documents, 17 buildings within the prohibited zone and 227 within the protected zone. 217 is relatable to 20 capital A of the Archaeological Act, where 100 meters only construction can be carried out by the archaeological officer, which is a deputy superintendent. And above that, deputy superintendent above. And 20 capital B is 200 meters regulated area where permissions, etc. have to be taken from ASI, and the ASI supervision it has to be happened. Now, the affidavit that the ASI has filed, they have, it's a concealment and a half truth in the matter, because they have there's only one paragraph which is relevant, which is in paragraph C capital C. I'm just your lordship. What they say is that Kamakhya temple has not been declared as a monument. But the point is, well, there is I filed photographs in my affidavit which I placed on record. It is a stone gateway, which is, as your lordship is standing under the Sitla Mata Mandir on the western side exit. There's that gate, stone gateway is a protected monument. On the left hand side, on the back, on the wall, steep wall, adjoining the temple where there's a small park, next to the Dhumavati, before Dhumavati. in fact, there is a dancing Bhairav. So these all fall within 100 meters. If those monuments are protected, and the definition of monument also in terms of the ASI Act means a structure or any inscription or anything. So the entire temple complex by
Mr. Hazarika, why have you approached and filed a writ petition?
What?
You have nothing to do with those things. We are concerned about this manner in which they are doing it, so that the geological survey or whatever it is required to be
Hydrogeological.
done is done in such a manner it is the hill is not affected, or whatever construction, if it is made, it is done in a proper manner.
If it is done, precisely, I am grateful to your lordship. Well, today this has only fallen out of their own, because out of the ASI affidavit, I have not said so. They have them. If they
I
had said
think
so.
the ASI, if anything is there, they are.
And my lord, proper
As
manner.
of now, no construction has started, they would obviously take notice if anything happens.
No, they have said it is not covered. They have said it. Your lordship will see their affidavit. They have said it's not protected.
So then they will take it. Yes, Mr.
But they have
Advocate,
said if it's not declared as a monument, your lordship will see.
Any development?
IIT and deputy made a joint inspection. Submitted the proposal. Now, all the dates and everything are being done, Only there is the issue regarding the timeline. So that negotiation is going on between LLC and the Hyderabad with IIT. That is in the process. I have the document for you.
So we have it.
All
some-
these, except the whatever IIT wanted, all these are being supplied or being committed by this Hyderabad.
Well, it's that
The
Hyder.
government.
Is the IIT a party here?
No, madam, this is the problem.
Why haven't you made it? It is your.
We'll- You should have not written that. We'll include them as a part. Your lordship may say so, we'll include them as a part. We'll include them as a part.
Huh?
Because madam, one,
Because
I'm,
that, you see, everywhere, the state government is saying that we are not going to do anything without taking the concurrence of the IIT. The IIT is there. So why you should have made the IIT a party.
we'll make them, your lordship. We'll find out.
That will expand the litigation.
But
Nothing is going to.
it will not.
Without IIT's consent.
My lords, today,
I am full submission. Again, I am reiterating that it's not a maintainable litigation now as of, because no private right is being in. I am.
No, Mr. Advocate General, therefore I say it. Now, when he was saying anything about archaeological, this court is not bothered with that.
The other-
I am only concerned out here that once you choose out that person concerned, we can end it. That person.
No, it's not only the Hyderabad is also.
no, my lords,
Run away.
that,
No.
but my lord, my apprehension is
Hyderabad
only
is-
one score.
Hyderabad is another aspect of it. Yeah, Hyderabad
Apprehension is only on.
is another person who would be a by the engaged by the LNT for that purpose. And in consultation with the IIT. Huh?
WT has engaged IIT.
Money is being
Understood.
given, my lords. Money, my lords, the only issue I have, we have no issues with the NGRI, we have checked it's an organization of the highest repute and standard. But my lords, today, the only issue and is minor but a significant issue is that if they are being engaged to the LNT, LNT is giving them the money, LNT is going to pay them the money. The scope of work, etc., may be very well vetted by IIT. At the end of the day, money, the paymasters are LNT. And LNT is paying the money to NGRI. So, my lords, and obviously, my lords, is evident now that the entire project, when it was conceived, designed, and construction, etc., carried out, that this whole water thing was not at all there. Because last time your lordships will remember, 24th of June was the first time we had issued.
Mr.
So my
Hazarika,
only concern
now
is, yeah, I'm
they
therefore,
are taking steps in that right
no,
line.
I'm grateful. So, my
Yeah.
lords, we will include the
In
IIT.
fact, we are grateful for you to pointing in.
My lords, we will include the IIT as a partner. Your lordship may just observe that. We'll find
Mhm.
additional.
That is, I'm just asking
No, we will
that
include them.
everywhere
I'm
it is
grateful.
there.
I'm grateful to your lordship. We will. Because the MOU was executed after.
Yes, Mr. Advocate General.
Regarding.
No, Let them file. I'm not impleading now. Let them file. We'll see. Mr. Advocate General, let the petition,
IIT has a standing council by learned friends, so they have a standing council.
no,
We can
whatever
call
may-
here immediately.
whatever
They,
may
my
be-
learned friend
may-
cannot be holding the bag for NGRI, LNT
No,
and everyone. Malad.
No,
He has
kindly,
to also
no,
share the
kindly
burden.
understand one thing,
Huh.
whether IIT would be a party is subject to an application being filed. Application is not being filed. It is only a thought being mooted by the council for the petitioner. So as of now, I think we need not before vacation trouble with the others as regards whether IIT should be made a party. We'll consider it then.
If that is
In
fine,
a more, in-
pollution control, you will also be necessary party. Third, MOUF will be a necessary party. This way the litigation cannot get prolonged.
No, Mr. Mr. Advocate General, the moment you come up and fix up that person concerned, that whoever it is. No, you, as of now, it has not finalized. Once it,
Only part, the only one of contention is the timeline.
no, whatever may be,
Timeline is
once,
by the
once you finalize him, we are going to therefore
Let the matter be adjourned for weeks.
benefit. No, that is what I'm saying. Obviously, we'll have it after vacations, whenever it is. But
Let them.
once it is,
whatever deadline.
you see, this court does not have the expertise also to look into how much, how it is to be done. These are specialized agencies shall do it. We are thankful for Mr. Hazarika for bringing it to the notice. Now the government is doing it, whatever means. Now, the thing is only you are to take care of that and the matter can be closed. Nothing remains here.
And then person. I person. The order. And IIT said the maker will be, we have to do in-depth analysis and for that 3D technology is used. Therefore, the government as well as I. Anything. So we have discussed and we thought that Hyderabad institution will be the right. So they have come up, they are on board now. They along with IIT, along with LNT and along with PWD, they did 3 days inspection of the whole combined site. I the whole from the delivery investigation reports also. And after that, the still process of investigation and all these hyper-technical things. That will require about 18 months. That 18 months, we are trying to. That is the only area where the final deal has to be made. Close the channel. So that is the area where we are now little bit lagging. So my humble submission is let the matter come up after 4 weeks. The meantime, notice will come up with a closing remarks.
It has been submitted by Mr. R.K.D. Chaudhary, the learned Deputy SDI, that an affidavit has been filed on behalf of the Union of India also. Response number 1 and 3. So in that regard, there is also a reply be filed by the petitioner. 1, 2, and 3. In that regard, a reply has also been filed by the petitioner on 1/10 today. So, Mr. D. Soikia, the learned Advocate General, submitted that the state government, the PWD authorities along with the IITG and the National Geophysical Research Institute, CSIR, National Geophysical Research Institute, have conducted recently a 3-day preliminary investigation. And on the basis thereof, there are various correspondences are going on. And in order to, on account of the timeline, there are certain negotiations going on. He therefore submitted that let the matter be listed after 4 weeks so that a more clearer picture can be placed before this court. Taking into account the above, list this matter again on when it is convenient.
28th of November.
Huh?
28th of November.
November?
Oh, sorry, October.
I am not the 28th. 28th?
Was date from 5th September to 7th September. And thereafter, this National Geophysical Research submitted a physically survey report and proposal for multi-parametric hydrophysical investigation. This proposal has also been.
You kindly give me, it is very difficult to pronounce. It's okay. Mr. D. Suikia, the learned advocate general, submitted that a joint inspection was carried out with the PWD, the CSIR Hikundiluna, CSI National Geophysical Research Institute, and the IITG from 5th of September to 7th of September. And thereupon, feasibility survey report and proposal have been submitted by the CSIR, that's the National Geophysical Research Institute. Houston. The same is being presently looked into by the IITG. Houston. He further submits that that on account of the timeline, certain negotiations are going on, and as such, the agency has not yet been finalized. The learned advocate general therefore submitted that the matter be listed after 4 weeks so that a much clearer image, picture can be placed before this court. Yes, 2810. List this matter again on 28/10/2024.
Great.
Huh?
So the file is very-
No, it's a-
it is the final judgment.
No, and that is why I'm returning. 2810. I won't be there, but somebody else will be there.
And then in which case, since it is matter,
Huh?
your lordship, we could have it on a date when your lordship is here.
Because I'm not here because I'm there in Mizoram from 21 to 1.
Then we can have it, then first week of November.
Can I have it on 8th of November?
Why not 8th of November? Can it be why not 4th of November? Is your lordship?
4th of November.
Because that, okay.
Who? Yeah, file the affidavit.
My lord, receive.
You file reply?
My lord, only they are already admitting my amount, but the claim. Only thing that they are saying that now this claim will become under the jurisdiction of Baksa division, not under Kuppers Act.
Payment is to be made this is for land acquisition.
No, my lord, regarding the payment of contextual fee, my lord.
So they have admitted that.
Yes, earlier also they are admitted. Only thing is they are saying that these documents, that this contract is come under the division of Baksa, not under Kuppers Act.
Who has filed the affidavit?
So this is filed by respondent number 4, my lord. Executive Engineer, Kokrasar Water Resource Division.
Respondent number 4. Executive engineer.
No, my lord, respondent 4 is the, my lord, Executive Engineer file is, my lord, respondent number 4, yes, Executive Engineer.
Then how is the executive engineer Pokraza Water Division saying this? That on one hand, he's saying it is not within his jurisdiction, and on the other hand, why the executive engineer has filed the affidavit? Should have been filed by the chief engineer or the BTC. Why the BTC has not filed? Why the BTC has not filed? Because on one hand, that executive engineer says that it is outside the jurisdiction of the Kokraza. and he's filing an affidavit. Tomorrow I pass an order on the basis thereof. You come up on the review, taking into account that when we have categorically mentioned it is outside my jurisdiction, then why did this court pass an order to that effect? So it should have been filed either by the BTC or by the chief engineer. Whatever may be, but the affidavit has to be filed. We are concerned with the BTC, not the police. Because on, I would have understood if he said that yes, it is in Kokrajhar division, he has filed that affidavit is okay, fantastic. But the moment he says that it is under the Buxar division and he files an affidavit, what is the value of that affidavit? Tell me. Isn't it?
Yes, ma'am.
This is the matter again on 28/10/2024. Bringing on record the affidavit filed by the respondent authorities. But you inform your colleagues about this. So you can't take up the duels then.
Orders, 36.
Oh, 36 not before me, na? So list of 9, no, it matter too. List of 9 to decide.
37.
Nothing, Your Lordship.
Who is appearing for respond number 3? Huh? Oh, I'll be. It will come under the social. You are appearing for whom? And 3, service is deemed to be complete.
Yes.
Service has been deemed to be complete because it has been received.
None of the respondents filed their affidavit.
Okay. From the above, from the order, from the order of the Lozima Court dated 16/9/2024, it transpires that the service upon the, all the respondents are complete. List this matter again on 20/11/2024. In the meantime, the respondents are done for admission in the admission column. In the meantime, the respondents are directed to bring on record their stand by filing an affidavit. Madam, you also appear for the justice. Who appears? WPT. WPT is no longer there. You are appearing for tribal affairs. Who appears for social justice? RM Das. Social justice has not been implemented. Next.
Yes, Lordship.
Yes, because the service is completed to the private one.
Service complete.
Yes.
Service from the order of the Lozima Court dated 6/9/2024, the service is complete and accordingly list this matter again for admission. What is the matter about?
Matter is, my lord, my mutation has been converted by the others, my lord. And thereafter the respondent has got cancelled. But land still is in air, my lord. I did not get the land.
This matter again on 22nd of November 2024 for the admission column.
Thirty-nine.
Service complete.
Taken steps, your lord.
Service complete list this matter for admission on 25/11/2020.
Interim, the interim will continue. your lord.
Interim order passed earlier shall continue till then.
Highly obliged, your lord.
Yes, what are you asking?
Herein, your lordship, the name of the applicant was wrongly written. And accordingly, this instant I has been filed, your lordship.
Huh?
Accordingly, this instant I has been filed. And on 2/9/2024, there is an order taking instruction to cause an inquiry for what is the actual name of the applicant. Whether she is the wife of the late Popular Gogoi or not.
Your name is what?
Nilima Gogoi. Nilima Gogoi.
It is there, Nilima Gogoi. Then,
But in the read petition, her name was wrongly written as Nilima Gogoi.
everywhere it is Nilima Gogoi.
Nilima, N and L, your lordship.
In the petition it is shown as Nilima.
Nilima, but it should be Nilima Gogoi.
Why didn't you show? Why have you later on realized this? How do I to take care of that? Tell me now.
Actually, this name is, but in the affidavit as well as in the Vokalatnama, your lordship, in that read petition, her name was, she put her name correctly as Nilima Gogoi.
It's all mistake of yours. So we do one thing, we impose a cost upon you, upon the lawyer. Pay 10,000 to your client and another 10,000 to the legal service authority. Yes, your name?
First part, your lordship, and because
On you.
that mistake, your lordship, I am admitting, your lordship, that mistake is on the part of us. But of course, both the name, your lordship, kindly see the name. One is Nilima, another one.
No, it is, you had the annexure 7 to the petition where it is shown as Nilima. Then why did you make it Nilima? This is a case of absolute carelessness on the part of the council. And for that, the petitioner is suffering. So we impose 10,000, which you will be paying it to your client and place before this court receipt and another 10,000 to the legal service authority. For that, you place the receipt with I. They have to be more careful. Who is the council? A.M. Khan.
Yes, yes.
You are
Myself
A.M.
and
Khan.
The council.
You are A.M. Khan.
Yes.
Right there. You people have to be more careful. You can't do this. Everywhere you have written it. Why did you write it? No, Wakalatnama confirm. Wakalatnama also it has been signed as Lilima.
Yes.
Then it is absolutely your fault.
Pronunciation of both this name is almost similar. Your
See, in the
Maybe-
affidavit also, she
Yes.
signed as Lilima.
Yes, yes.
Then you shouldn't have done it. Or is it that you put the signature earlier?
Maybe for the reason that the pronunciation of.
Didn't it, madam? Since he took the signature earlier because there's no deponent below that. You got the blank signatures out there, you have taken it and filed it.
Which are in the affidavit.
Yes.
No, no.
Yes, I'm telling you. The council, I have been also a lawyer. I know it, what you have done. Why there is no deponent below the name of the affidavit? When a person signs as Nilima, why did you put Nilima?
So therefore, I'm saying, Your Lordship, since both this name.
So we have to recall the entire order because if it is signed by a person named Lilima, the affidavit is wrong. The affidavit says Nilima, signed by Lilima. We recall the order, entire order.
That
We recall the order.
it may, therefore only I am saying, Your Lordship,
I'm recalling the order.
the pronunciation.
This
of
order has been wrongly passed at the behest of a false affidavit.
That's all, Your Lordship, I want to.
Either pay 10,000 to your client as well as another 10,000 to the legal services authority, else we are going to do.
I am leaving it to you.
You pay the 10,000, show the receipt, then we pass the order. I acknowledge. Heard Mr. A.M. Khan, the learned counsel appearing on behalf of the petitioner. Ms. P.R. Mukunto, the learned counsel appears on behalf of the Revenue Department of the Government of Assam. And Mr. B.J. Talukdar, the learned additional senior government appearing on behalf of the district administration. This application so far is a case where the petitioner, who is a widow, have been taken for a ride by the council representing the petition. The documents accompanying the writ petition and even the affidavit categorically shows that the name of the petitioner is Lilima Gogoi, Lilma. Lilma. But for reasons best known, it has been mentioned as, but in reasons best known, the entire writ petition has been filed as Nilima Gogoi, Nilima, Nilima. It is on account of that mistake which has been committed by the council appearing on behalf of the petitioner. The petitioner, who is a widow, is suffering as she is not in a position to get the benefit of an order being passed by this court on 2/9/2024. Passed by this court on 28/8/2023. The act on the part of the councils is strongly deprecated and the conduct is reprimanded. Be that as it may, it being a settled law that a person should not suffer on account of the fault of their client, but the fault of the council. This court allows the instant application, thereby observing that the name appearing in the writ petition as well as the orders passed in WPC number 4059/2021 be read as be read as Lilima Gogoi and not Srimati Nilima Gogoi. The respondent authority shall, on the basis of the instant order, permit the petitioner, that is Srimati Nilima Gogoi, LIL, the benefit of the order dated 28/8/2023, passed in WPC number 4059/2021. With the above, the instant I stands allowed. Hey, black and blue, नाम लिखिए.
Time you are using it. Because in earlier order, it was 2 month time there was. But discussing the benefit you are in earlier order, it was 2 months. That 2 months has already expired your lordship. So hearing your lordship, if your lordship will mention from its prime.
The period which have been mentioned in the order dated 28/8/2023 would stand extended by another period of 2 months from the date of the present order.
41.
Mr. Council, be careful next time. On account of vacations being coming, I have been more generous. Yes, madam, tell me.
The marriage is registered, your
41. What have you done?
marriage is registered of both the petitioners.
What do you want? Issue notice.
As per the last order, your lordship, 21/8/2024, your lordship directed to apprise this court.
Apply before whether the marriage between both the petitioners have been duly registered. Okay. They've been registered.
Yes.
Now, what is the case
The
about?
purpose of this writ petition is
The
served.
petitioner who has submitted an application for the entire, oh, it is closed.
Yes.
Okay, done. The learned counsel appearing on behalf of the petitioner submitted that pursuant to the orders being passed on 5/8/2024 and 21/8/2024 by this court, the marriage between the petitioner and the respondent, and both the petitioners, na?
Yes.
Have been duly registered on 18/9/2024. And in that regard, have placed before this court the certificate of marriage. Same is kept on record and marked with the letter X. Taking into account the above, the instant application with petition stands closed as infructuous.
Obliged.
Oh, before time.